Resultantly, the writ petition is dismissed and in the circumstances without any order as to causes.
Item number 2.
In view of the above discussions, we do not find any ground to interfere with the orders of the disciplinary authority as well as the order of the London Central Administrative Tribunal. Accordingly, the writ petition being devoid of any merit is dismissed. Okay.
Observation.
Bill application.
Bail application.
3rd November.
Lordship, another bail application is 5879/2021, Lordship.
10th November.
Lordship, 10th.
November.
Lordship, it's a old man, Lordship, 74 years old. Kindly consider.
All right. 25th October.
May pardon to make a mention, Lordship. Today's supplementary list item 23, my lord. Item 20.
Rajendra Prasad Biswal.
Yes, your lordship.
What do you want?
Well, in this case, my lord, the file has been misplaced by
No, no. Let it be called up. Not adjourned. Please.
Like,
Supplemental list fresh admission item number 3. Item number 3.
May I please, your lordship?
Yes.
With due respect, your lordships, I beg excuse of the London councils for the petition.
My lord,
But
here.
Mr. Pandey-
My lord,
Pandey-
so far the item connected item 3, that is writ appeal 471 of 2021. If I place it, my learned friend permit me,
Yes.
because the authorities have challenged
Yes,
also that transfer
Yes.
order.
Mr. Pandey is on accommodation, your lordship, because of his counseling in the Ravensa University. So I pray only one day accommodation, the Lord.
My lord, difficulty is that they are
Only one
pursuing in
day.
the contempt matter. They are pursuing contempt also. So that is the difficulty in the transfer order, that my lord, the principle settled by the lordship himself, and that is bereft of policy, bereft of rules and procedures. Also, it's the prerogative of the employer to transfer an employee. And my lord, despite that being cited also, this order has been passed. And if your lordship will permit me, then I can place the impugned order is annexure 1.
You are for the appellant, Mr. Mohanty.
Yes.
Yes, yes, my lord.
All
Because
right.
the authorities have challenged this.
All right.
My lord. My lord.
We pray only, your lordship, tomorrow, your lordship.
The
If it can
appellant, the appellants are all individuals, right?
At
No, no, my
appellant,
lord.
individual.
472,
Item
472 and there are 2 by individuals and 2 by the state.
Individual, they are affected party, my lord, for which they have individual file, my lord.
How are
But the
they
policy-
affected? They were to
Common-
come to
common
this place,
judgment.
is it?
Common judgment.
Common judgment, my lord, without
And,
giving any
and
opportunity,
the
this
last
order
two
has been passed,
matters.
my lord.
Last
All
two
right, you
matters.
take us through the judgment.
My lord, yes. My lord, before I take your lordships to the judgment, my lord, lordship kindly bear in mind and consider that this Orissa School Education Program Authority is to implement the Sarva Shiksha Abhijan. Sarva Shiksha Abhijan is a joint scheme of the central government and state government, and this is all schematic appointment, all appointment are on contractual basis. That is also admitted facts. And my lord, they are 1 yearly the appointment is given, contractual. Now, my lord, lordship kindly see, my lord, this judgment starts, some relevant person I'll submit before your lordships. My lord, kindly come to page 20. My lord,
Yes.
para
Yes.
2. Essentially, both the writ petitions, both the writ appeals, last 2 writ appeals who have filed, because 2 writ petitions have been filed by the contractual employees working under the Orissa Private Education Program Authority in different capacities.
Which paragraph? This is, you're reading the impugned order.
Yes.
Which paragraph?
Page 20, paragraph
Para
2.
number.
Para 2.
Pages are, he's referring to some other.
Internal
You are
page
referring
3,
to WA 471, Mr. Mohanty?
471.
Ah, 1 minute.
My lord, is there any confusion from my side? It is the internal page 3 of the judgment. Lordship got it?
1 minute, please. 1 minute. Ah, right. Yes.
My lord. both the writ petitions have been filed by the contractual employees working under OPEPA in different capacities seeking to quash the transfer order. Then Lordship, three. My Lord, kindly see. The factual matrix which has given rise to filing the writ petition is that the petitioner therein was engaged as financial consultant in DPO SSA Malkanagiri. My Lord, kindly mark it, Malkanagiri, on contractual basis by order number so and so with remuneration 6,000. My Lord, this 6,000 is started getting 47,000 something. While he was in continuing, he was disengaged and again re-engaged by the office order dated so and so in Ganjam. My Lord, from Malkanagiri to Ganjam, there has been several transfer orders they have suffered. While working as such, again he was engaged in SS Kendrapada by the office order dated for 12/5/2018 and continuing as such till the impugned order of transfer was passed. But here only 3 districts have been given. I will show your lordship several transfers they have suffered. Then 4 is paragraph 4. This is so far the other petitioner is concerned of the other the last retable tax. The factual matrix which led to filing WPC so and so is that the petitioner therein was initially engaged as coordinator pedagogy in DPO on contractual basis. Thereafter, she was transferred to DPC office on Angul on 17/6/2010 and subsequently she was placed at DPC office Keonjhar. Then again, authority deployed her in the head office of OPEPA. And after cancellation of her deputation period, the petitioner was again.
Just come to para 17. Para 17.
Para 17. My Lord, yes. The close reading of definition prescribed in Rule 3A of OPEPA Service Rules and Regulation 96, it appears that it does not include the officer and staff engaged in contractual basis. They neither Rule 24 nor the definition prescribed under Rule 3A deals with contractual employees working under the OPEPA under Rule 24(1) reference. Lordship, kindly see the classification of employees, clause 2. The classification of officers for the purpose of 4 in connection with the officers of the authority. The officers of the authority, including those working on deputation from state, so and so. Then, Lordship, kindly straight come to next page 18, clause 3. Higher grade, all employees appointed on lump sum contract. Well, that is covered. The contractual employee, only contractor employees are employed in the OSEPA, and only some staff come on deputation from the government. My Lord, here the Honorable Single Judge is not correct. Then Lordship also kindly see the definition, page 17. The officers and staff, I am reading from the top. The officers and staff means whole-time employees of the authority appointed by the executive committee or by any officer or authority delegated with power to executive committee to do so, and would also include consultant, fellows, research staff and officers and staff working under the authority of deputation from there. That means the contractual employees, including also the authority, those are coming on deputation also from the government. Then
Was there a stay, Mr. Monty?
My Lord.
Was there a stay granted when the matter was pending before the single judge?
My Lord, stay was granted, and we have filed the application saying that he has been relieved, and he has been relieved since then. He has not been allowed to join. In the meanwhile, the contract period has also lapsed. That I have stated in paragraph. Also, Lordship, kindly see.
And the contract has not been renewed.
No, it has not been renewed also because it is subject.
Then it's all infructuous then.
My Lord,
if the contract has not been renewed, it is infructuous then.
Contract has not been renewed.
That's end of the matter. Then what is the point? Even if you succeed, he can't join.
My Lord, that is right. But the principle is
that's
decided.
The end of the matter, Mr. Monty.
My Lord, but
the contracts have not been renewed. Even if we set aside this judgment, he won't join.
This is my instruction. It has because 1 year contractual.
That's the end of the matter then. Why bother?
But my lord, only I am conscious of the
We leave
things
the
that
question of law open. We
question
leave
of
the
law is
question of
that,
law open. Since contracts have not been renewed, we simply leave the questions open.
my lord, one thing lordship may appreciate. My lord, if this principle remains,
Mr. Monty, we'll say that the impugned order will not constitute a precedent. We leave the questions of law open, all right?
that your lordship may record my submission. They have not been
Mr.
renewed
Monty, in the
also.
course of his submission, points out that the contractual employees in question, the contracts of the contractual employees in question have not been extended. In that view of the matter, even if this court were to allow the writ appeals and set aside the impugned order of the single judge, no purpose would be served, since in any event, such employees cannot join duty at the transferred place. Paragraph. In view of the above development, while clarifying that the impugned judgment of the learned single judge will not constitute a precedent, and while leaving the questions of law raised in these writ appeals open for consideration in another appropriate
My
place,
lord, the
these appeals are disposed of.
contempt proceedings are pending. My
So
lord, the
they're
contempt
same thing. You tell them the contract is not renewed. There's a question of contempt. All right.
All the,
my lord,
All appeals are disposed of.
item number 4.
May I please, my lord? My lord, we are street vendors and we are being given all the idea. Our area has already been surveyed. We are also issued the street vending identity cards. That despite, my lord, paragraph 2 I have mentioned that despite there is a recurring threat on us and they are not giving in direction for
That
opening of-
recurring threat is neither here nor there. Something concrete you have to tell us.
Well, the concrete is they have to allot us a kiosk. No.
This petition, Mr. Monty, you filed this petition in February 2021, correct?
Well,
And today we are in almost middle of September.
well,
So in the last 7 months, if they have not touched you, there's no need to have apprehension now.
so there is no apprehension to that. But my
So
prayer
you
is, my
renew,
lord,
you renew. When there is a
my
genuine
lord,
apprehension, you come forward. All right.
my lord, only my prayer is, my lord, just have a glance. My prayer is to declare our vending zone as a to declare the vending area of the person being vending zone, my lord, and to allot shop rooms.
Have
as
you
per
made
the
some
vending norms.
representation? Have you made?
My lord, we have submitted the
what representation? I don't see any copy.
No,
You
no,
make a
well,
representation first. You say the petitioners who are stated to be street vendors in different areas in district Khurda have filed this petition way back on 8 February 2021, apprehending eviction by the Bhubaneswar Development Authority. Paragraph. Clearly, in the past 7.5 months, there is no such drive undertaken, and the petitioners are continuing as such. Paragraph. Mr. Monty then says that a direction should be issued to the BDA to declare the area where the petitioners are operating as a zoning. What is that? Hawking zone.
vending zone.
As a vending zone. Full stop. The court finds that there is not even any representation yet made for that purpose. Full stop.
We may be permitted to some.
If the petitioners make such a representation to the BDA, not later than 4th October 2021, it will be examined on merits by the commissioner. Is it BMC or BDA?
BMC.
BMC. And preferably after giving a few representatives of the petitioners a hearing, a reasoned order will be passed not later than 6th December 2021 and be communicated to the petitioners not later than 13th December 2021. The petition is disposed of in the above place.
But I am appealing for the state.
Yes, all right.
Item number 5.
May I submit?
Yes.
Same case is an item number 20.
20
Yes,
is
my
it?
lord. 20.
20 is the same order.
20.
All right.
My lord. Oh, bless you.
Item 5.
May I please, your lordship? The petitioner has purchased the land in the year 2004 and set up a industry. For that, he has obtained the registration from DIC, air pollution certificate and water pollution certificate. And there, since 2004 to 19, he was operating a refractory industries over the shoot land. And in 2019, he received a notice from the MCL that this land has been acquired way back in the year 1981. From 1981 till the date of my purchase in 2004, neither any steps was taken nor any award has been passed in favor of my vendor or to me also. I am a purchaser. The law is well settled that the purchaser of a acquired land cannot challenge the notification made under the Land Acquisition Act, but he steps to the shoes of the vendor and he is entitled for the compensation. To that effect, a lawyer's notice was issued under Annexure 9 at page 59, and they have passed order for my eviction without making a measurement and conducting a survey over my land. I am ready to give up my industry if because I cannot challenge the acquisition notification. Being a landowner, since I have purchased the land from the rightful owner, I am entitled for the compensation. The compensation has not been provided.
Sir, if your date of your sale deed is after the date of the Section 6 notification, if it is after the award, 1 minute. If the date of your sale deed is after the date of the award, it is an invalid sale deed. All right.
My lord.
So you cannot get any compensation.
My lord, in Santi Sports case 2009 15 SEC page 705, paragraph 63, the Honorable Supreme Court have held that the subsequent purchaser is entitled for the compensation. That has been again reiterated.
Which is that case?
2009.
No, cost title.
Santi Sports.
All this is no longer good law. This is no longer a good law after Indoor Development Authority. Have you studied the Indoor Development Authority case?
My lord, Indoor Development Authority's case I have studied. They are talking about 24(2). But the Indoor Development Authority's constitutional bench judgment is not dealing with the subsequent purchaser.
Yes, of course it is. Of course it is. You have no valid title, you cannot get compensation, sir.
No, my lord, this is 2009.
If you have purchased it long after the land is vested in the state, it is in fact a fraudulent sale.
My lord, I am reading out paragraph 63. A transferee of the acquired land can at best step into the shoes of the landowner and lodge claim for compensation.
That is taking place prior to the vesting of the land in the state, not after.
My lord, your lordship, this is an acquisition under the Coal Bearing Land Acquisition Act.
Whatever it is.
If the land will be acquired in 1981, the
no question, sir. You have no title to convey to you. It's not a valid sale deed at all.
Even if this, therefore I cannot challenge the notification. But I am
you cannot even claim compensation. The sale itself is invalid, sir. He had no title to convey to you.
These aspects
he ceased to be the owner. He could not have conveyed any title to you.
My lord, there are two judgments occupying the field. One is Santi Sports 2009 15 SEC 705. The another is 2012 12 SEC page 133. That is the case where the Honorable Supreme Court have also taken.
Either you give us copies of those judgments if you want to. You cannot argue your case before a high court without giving us copies of the judgments you're relying on.
Oblige, I've sent the copies. Your lordship may take up some other day. I will supply the copy.
The petitioner seeks some time to produce the judgments he wants to rely on. List after 4 weeks.
Item number 6.
May I please? Page 51 is the order input, my lord. I have given also copy of my lord's order for the court master. It passed in WPC number 4100 of 2021. In similar matter,
It's already dismissed. All right.
No.
In view of the judgment dated 20th April 2021 in WP Civil number 4100 of 2021, this writ petition is dismissed. All right.
Item 7.
item 7 of
Same. All right.
Item 8.
My lord, on behalf of Mr. Nayak, Gopal Krishna Nayak, with the suffering from fever, I play adjourned the next week, my lord.
Counsel for the petitioner is stated to be unwell. List after 8 weeks.
Item 9.
On behalf of Mr. Matter will be adjourned to after 25th manner. He is in quarantine. And
The Lordship can dispose of the matter because after that law came, perhaps he has not taken note of that. That is the central law, the Street Vendors Protection of Livelihood and Regulations of Street Vending Act 2014. And he has referred to the state regulations. And we are taking steps. We are taking steps, and all state vendors are identified. And whoever comes to the court also by saying
No,
that
but his prayer clause is that Street Vendors Act only.
my lord, Mr. P.K. is the conducting lawyer in this case, and he is in quarantine due to family members are infected in COVID, and he is in Baripada and interior of Orissa, and the internet connection is also very poor there. And one chance may be given to submit him, my lord. Any day.
But what is praying for that we are obviously we are bound to do as per the law. I am appealing for BMC.
All right. Appearing on advance notice, counsel for the BMC states that steps are being in fact taken to conduct surveys in terms of the Street Vendors Protection of Livelihood and Regulation of Street Vending Act 2014. And that all actions taken would be strictly in accordance with law. That view of the matter, no further directions are called for at this stage. The petition is disposed of.
Alright, I am for OP number 2, the BMC in both 1 and 2 matter.
All right.
I'm appealing for the statement.
All right.
No,
Item number 10.
Good redressal committee has also framed in.
May I please, your lordships?
Well, item 10, I am appearing for the statement. This is covered by the batch of judgment, that is WPC 14924 of 2020, judgment dated 7/6/2021.
Correct. Yes, Ms. Roy Chaudhary.
Your lordship, similar matters are pending before your lordships, and the review petitions. Your lordships have been pleased to put it for 2nd November for hearing, your lordships. In the meantime, I will file the compilation of notification and the judgment I have cited in this.
2nd November.
All those are different matters. They are review petitions.
That's right. All this is covered, Ms. Roy Chaudhary. This is completely covered.
Some review petitions have already been disposed of by my lords also.
Your lordships, partly it is covered so far as the page 12.
Same prayers.
Yes. So,
Yeah, you say in view of the judgment dated 7 June 2021. 12 June or 7 June?
7 June, your lordships.
7 June. In
Yes.
petition so and so.
14924 of 2020.
Yeah, this petition is disposed of. All right.
Oblige, your lordships.
Item 11.
Hearing on behalf of opposite party number 9, your lordship.
All right.
My lord, obliged.
In 11, as it may please your lordships, an affidavit has come, but my lord, in a matter of such an important area that where my lords, it's a non-adversarial matter and the health infrastructure should be known to the state at least and should be given to the honorable court. My lord, the affidavit neither contains the number of hospitals in a district or block or panchayat, nor the category of the hospitals, nor the staff employed there, nor whether the equipments are working, whether any equipment is there. Not a single material particular is there in the affidavit. And no purpose is going to serve by this sort of an affidavit in an important matter like this, where health infrastructure needs to be seen, and whether we are prepared to meet the needs of the rural people in Orissa. I think
Let's have
Am I
having
audible,
some
Madam?
copies of the affidavit.
Affidavit.
Current senior is so much dissatisfied with
I have
affidavit, he present it because I have filed it, so I take the responsibility to present it, Madam. So may kindly find the order. Lordship, I have directed 1, 2, 3, 4, 5. I have quoted the order, Lordship. Let me kindly find the at page 2, internal page 2 of that affidavit dated 13/9/2021. Roman 1, Roman 2.
Yes.
Lordship, one is what is the extent of availability of health facilities, both public and private, in each of the 30 districts, including urban and rural areas in Orissa. Well, Lord, this has to be presented to start with for Kalahandi and Navrampur. Well, let's may kindly take paragraph 4. That it is only submitted that as regards the availability of testing facilities, the procedure and the evolution of COVID-19 testing in Orissa is to be presented before the Honorable Court for kind appreciation. The first case of COVID-19 was identified in Orissa during March 2020, and at that time there was only one viral testing laboratory to undertake reverse transcript polymerase chain reaction, wherein after RT-PCR for short test in the state of Orissa, that is Regional Medical Research Laboratory (RMRC), under the administrative control of ICMR, Government of India, Bhubaneswar. 4.1. As it was decided by the Government of Orissa to provide free testing, free transport, and free treatment facility to COVID-19 patients, the Government of Orissa has implemented the following decisions. 1. To increase the testing facility and to establish RT-PCR laboratories depending on availability of equipment. 2. Adequate mechanism of collection and transportation of samples from all districts to tag laboratories. 3. To follow the ICMR guideline and standard operating procedure for sample collection, transportation, and testing, and uploading the testing results in ICMR portal. 4. To recruit additional manpower and vehicles for swab collection and transportation of samples. 5. To establish dedicated COVID-19 treatment centers such as temporary medical camps, COVID care homes, COVID care center, dedicated COVID health center, dedicated COVID hospitals. 6. To use private healthcare facilities as dedicated COVID care hospitals. 4.2 Lordship. Throughout the pandemic, the testing was done as per guideline issued from time to time by ICMR and treatment as per guideline issued by the Government of India time to time. In this manner, these guidelines were revised. 4.3. The surveillance of fever cases as suspects in the village under rural areas are done by ASA, Anganwadi workers, followed by health worker male and health worker female. To arrange swab collection camps through mobile swab collection team as per advisory on strategy for COVID-19 testing, ICMR version 6, annexure A by 2, and they also facilitate transportation of these persons. 4.4. For testing, the strategy for COVID-19 testing in India version 5 dated 18/5/20, annexure B by 2, as used for guide to select the person who are to be tested. 4.5. Initially, all tests are done by the RT-PCR method, and subsequently, TrueNAT test and rapid antigen test were made available from July 2020. The rapid antigen test was used as ICMR guideline following advisory on strategy for COVID-19 testing in India, version 6, 4 September 2020. The RT-PCR method is done in state-of-art BSL-2 plus laboratories with dedicated RT-PCR machines. Because of stringent lockdown measures and restriction in interstate movement, it was difficult to establish new RT-PCR laboratory. However, Government of Orissa could manage to establish 19 number of RT-PCR laboratories under the Government of India and Government of Orissa, and 4 laboratories in private laboratories are allowed. Total 23 number of RT-PCR labs have been established before 14/1/2021. ICMR recognized list of laboratories as on 14/1/2021 is exposed unit and marked as annexes C by 2. By now, another 18 number of district RT-PCR lab have started covering at least one RT-PCR laboratory in each district. 4.6. At present, 47 laboratories under government setting and 20 numbers of private laboratories are authorized to provide RT-PCR TrueNAT RAT test as per the rate fixed by the Government of Orissa from time to time. These private laboratories are mostly in Bhubaneswar, Cuttack, Bargarh, Rourkela, catering to urban population at government approved price. Hence, there is very little chance of the rural tribal people in other areas getting exploited by the private laboratories.
Mr. Sahu,
That's it.
what we even decided in the last occasion,
That's it, please.
in para 4 of our order,
That's it, please.
we said after the affidavit is filed, we'll request the DLSAs to utilize paralegal workers to report on the ground situation.
Indeed, your lordship.
So what we can do is request the DLSAs both in Kalahandi and Nabarangpur
I'll forward copies of this.
to actually go and visit these places and find out what the ground situation is.
My lord, they may take into account the health infrastructure as indicated by
No,
the
no,
city.
we'll give them copies of these affidavits, then we will know.
I will not. My lords, may I kindly take annexure I and J. They have to verify those I and J because that is district specific I and J. My lord, that would be at page. I'm sorry.
Page?
I'm just giving that page, lordship. My lord, I at page 28 to 32.
That is Kalahandi, and J is where?
33 to 39.
That's Nabarangpur.
Lordship.
All right. All right.
My lord, also permit me to file an affidavit, my lord, on my, I have done my own research and investigation, my lord.
Yes,
there.
yes, please do. Please do, Mr. Joshi. Pat Joshi. Please do that. You say, pursuant to the order passed with this court on 7 September 2015, an affidavit has been filed by the Additional Chief Secretary, Department of Health and Family Welfare, seeking to address the issues highlighted in the said order on availability of RT-PCR and rapid antigen testing in the rural areas. Paragraph. Mr. Padjoshi, your senior counsel appearing for the petitioner, has expresses reservations and states that on the affidavit and states that he would like to file a response thereto. He is permitted to do so before the next date. Paragraph. In para 4 of the order dated 7th September 2021, this court had indicated that after the affidavit is filed by the state, the court would request the respective district legal services authorities, bracket DLSAs, in both Kalahandi and Nabarangpur to utilize the services of paralegal workers to report on the ground situation in each of the districts. Paragraph. Enclosed is annexure I bar 2 to the affidavit is the relevant information regarding the facilities available in Kalahandi, and annexure J by 2, the facilities available in Nabarangpur. A copy of this affidavit shall be immediately transmitted. A soft copy of this affidavit will be immediately transmitted by email to the secretaries of the DLSAs at Kalahandi and Nabarangpur. They will within the next 2 days constitute a team of 5 paralegal workers, which may also include any young advocates who are empaneled with the DLSAs, to visit each of the facilities pointed out in the respective districts in annexure I2 and J2 and submit a comprehensive report to the secretary, concerned secretary of the DLSA on the above aspects at 1 to 5 highlighted in the order dated 7 September, in para 1 of the order dated 7 September 2021. And also if there's any discrepancy, and also what the ground situation is in each of the districts. They may also want to enclose photographs or video clips with their respective reports. The secretary DLSAs may fix the honorarium to be paid to the paralegal workers who will undertake the work. The reports be submitted by the paralegal workers, public advocates to the secretaries, respective secretaries, not later than October 2021. It will be immediately sent by the secretary DLSs to this court the registry will provide advance copies of those reports to the learned AGA as well as to Mr. Padjoshi forthwith. List on, we'll have it on 5th October.
As it convenient.
All right, 5th October. Right.
Item 12.
I'm deeply.
Well, my lord, I have filed a caveat petition, but they have not served the copy of the petition, my lord. And, Lordship may kindly, this is the regarding release of the vehicle, my lord. Perhaps this is a single bench matter. But however, I have filed the caveat petition, my lord, on behalf of the opposite party. They have to serve a copy.
No, anyway, who's for the state?
This honorable court has also previously passed an order in favor
1
of.
minute, please. 1 minute. Let us find out who's for the state.
Well, I'm appealing for state. Sorry.
Yes, tell us what the matter is about.
The petitioner state challenges the order passed by the Honorable District Judge and it's setting aside the order passed by the confiscation order passed by the appropriate authority. I take my notes to the order before my notes. On the ground, my notes that the state it suffers from non-compliance of principle of natural justice. My lord, that is the soul of the judgment rendered by the Honorable District Judge.
Right.
My humble submission, my lords, may kindly find at page 26 the SOCO's affidavit, the reply at 27 and 29 pages. Thereafter, what has happened, my lords, he did not appear pursuant to the notice. Then the order was passed. My lord, may I submit if my learned friend agrees, let it be remanded if he wants a fresh opportunity, my lords, because beyond that, my lord, the facts are not disputed. It is a case where the truck was seized carrying manganese in a forest area. Not even outside the forest area. It is inside the forest area. And the sole explanation by the truck owner is that his driver is innocent. He was made to believe that it is possible inside forest area. And it was carrying manganese ore along with wooden plants or wooden trees. Different type of trees.
It goes back to the authorized officer.
Because, my lord, then he would say the fact-finding authority has not given the opportunity.
The district judge has said because the authorized officer did not give opportunity, the whole matter. It goes back to the authorized officer. That, Mr. Pandey, you cannot object to that.
My lord, this honorable court, the honorable single judge, my lord, in WPC number 15451 of 2021, by the order dated 7/7/2021, passed an order to release the vehicle, my lord. Thereafter, they have filed this writ petition, my lord. Because despite of the order passed by the single judge, my learned district judge, my lord.
How did you also go to the district judge? You went parallel.
Yes, my lord. Appeal is permissible, my lord. I have challenged the order
So
passed by the authorized officer in the
1 minute.
my lord.
1 minute, please. So, despite succeeding before the district judge, you also filed a petition
for release of the vehicle, because despite of the order of the district judge, my lord, they didn't release the vehicle in favor of me, my lord. For that reason, I filed the writ petition, and this honorable court on 7/7/2021 passed an order to release the vehicle, my lord.
Where is that? Where is that order?
My lord, that they have annexed or not, I don't know, because
they've not. They've not even mentioned it. They've not even mentioned this fact.
They have not served the copy of the writ petition, so I am not aware about the facts what they have stated.
My lord, page 4, paragraph 3. Page 4 of my lord's brief, paragraph 3.
Otherwise, your lordship may call for that.
You have not challenged that, Mr. Sahu.
My lord, sir, that has not been challenged because my lord, sir, because that is not on merits. The other part of the submission is that, my lord, that order is in effect.
This is a subsequent order. If you not challenge its certain finality, this is a High Court order.
Yes, as far as release is concerned, my lords.
It must be on the ground that despite the order in the appeal, they are not released.
Correct. I think that's become final. It's merged with this. You say it appears that after the learned district judge, Bolangir, passed the impugned order dated 26th February 2021 in FAO number 6 of 2020 in favor of the opposite party, asking the vehicle in question to be released, the opposite party filed writ petition civil 15451 of 2021, which came to be allowed by a learned single judge on 7 July 2021, asking the authorities to release the vehicle in favor of the opposite party. This is mentioned in para 3 of the writ petition itself. Paragraph, Mr. Sahul on AGA, when asked whether the above order dated 7 July 2021 of the learned single judge has been challenged, replied in the negative. Paragraph. In view of the above development, the court sees no reason at this stage to interfere with the impugned order dated 26 February 2021 of the learned district judge in FAO number 6 of 2020. The writ petition is accordingly dismissed.
Item 13. Observe the questions of law may be kept open.
Not necessary, Mr. Sahul. Not in this case. Yes.
Item 13.
It's all on a case-by-case basis. Yes.
So this is an application related to recruitment of the presiding officers in the debt recovery tribunals, Your Lordship. Your Lordship, kindly go to page 35, annexure 2. An advertisement was made by the opposite party Union of India taking application for the post of presiding officer DRT. The para 2 of this application says, advertisement says, the eligibility required for appointment to the post of presiding officer of a DRT is as under. A person shall not be qualified for appointment as the presiding officer of a tribunal unless he is or has been or is qualified to be a district judge. Qualified to be a district judge, Your Lordship, it is only 7 years experience in the bar, Your Lordship. Pursuant to which I have applied for the said post at the page 37 at annexure 3. And when this matter was pending thus, the opposite party Union of India at annexure 5, page 58, issued another advertisement dated 23rd June 2020. Kindly go to the line 7 of the first paragraph.
You're overage now, is it?
No, Your Lordship.
Oh.
No, the age is 62.
Then how does it prejudice you? That's a new advertisement.
I'm coming to it.
You come to that straight away.
Yes, straight away. Yes, yes. Then Your Lordship, kindly go to in the meantime, they have issued another 2 advertisements taking the shelter of a rule amendment to the Rule 20 of the member judicial.
Sir, how does all that prejudice you?
What prejudice me? Kindly go to page 128, annexure 7. 12th July 2021. They have issued another advertisement. What they have said, a person shall not be qualified for appointment as presiding officer of the debt recovery tribunal unless he is or has been a district judge. Eligibility portion that has been deleted. That way, the advocates have been given a gun by to apply for this post. At this particular rule.
No, unless you challenge, have you challenged this rule?
Yes, sir.
Have you challenged this amended rule?
Yes, yes.
No.
That amendment rule was challenged before the Honorable Supreme Court. Kindly go to the page, annexure 6, page 60. It's a long judgment delivered by full bench of the Supreme Court, led by Justice L. Narsim Nageswar Rao.
What's the date of the judgment?
What they said.
No. What is the date of that judgment?
I am coming to that. That judgment.
What is the date of the judgment, sir?
Yes, I am coming to that.
You have to answer. What is this coming to that? What is the date of this judgment?
Date is
27/11/2020.
Yes, 20.
So this amendment is after that judgment?
No.
What is the date of the judgment?
27 November 2020.
What's the date of the amendment?
Amendment is coming. This amendment is 20th February 2020 as page 39 annexure 4, in which they have excluded advocates to apply for this post. Annexure 4, page 39. The relevant portion is here at page 51, paragraph 8. Debt Recovery Tribunal under the Recovery of Debts that Act. A person shall not be qualified for the appointment as a presiding officer of the Debt Recovery Tribunal unless he is or has been a district judge. Therefore, the advocates have been excluded to apply for this post. And this notification was challenged before the Supreme Court in this impugned judgment. In this impugned judgment, the Honorable Supreme Court says that this notification cannot take a retrospective effect because I have applied for this post in 2019. And the advocates shall be eligible to apply for the post if they are having 10 years of experience at the bar. While dealing with the issue, the learned Attorney General has made a submission that advocates having 25 years should be considered for that post. Come to page 103. But
what have they done pursuant to the new advertisement? Where has it reached?
Yeah, let's see.
Pursuant to the new advertisement.
Yeah, let's see.
Where are we now? That was an advertisement dated 12th July.
Yes.
What is the current position?
Current position, I don't know.
You don't know?
How I can have an idea of what the government is doing?
No, you know what's the last date for filing applications?
Yes, the last date. Last date is over. It was 12 July. It was probably in 12th August somewhere. This might be under process, Your Lordship.
Which page is the advertisement?
Advertisement page 128.
Let's see the paragraph 2.
Last date is 24th August 2021.
And you have not applied, obviously, because you're not qualified now.
Because
you're not qualified.
Yes, I'm qualified. I've been excluded.
No, you want to only be a presiding officer. You do not want to be a member.
So that is the advertisement. Member that was not advertised pursuant to this advertisement of.
Only presiding officer.
Yes, only presiding officer. And now this notification of 2020 have been elaborately dealt with by the Supreme Court in this judgment by the Supreme.
They've again enacted some rules now. What are those rules? Does it not cover the DRT?
No, they are not enacted because this is a 2020 rule.
No, sir. Recently they've amended the last Parliament session. They
Even if Your Lordship, they have amended the rule, can that rule override the decision of the Supreme Court?
No. In fact, there is a criticism from what we read in the press.
Yes.
With the judges expressing reservation that despite their judgment, they've again enacted rules.
Before 7 days, there is a amendment rules is coming in recent Parliament. That is correct. Before 7 or 10 days.
Anyway, Mr. Party, you accept notice. You say it is pointed out by the petitioner who appears in person that the fresh advertisement issued on 7 July 2021 for the post of presiding officers of the Debt Recovery Tribunal introduces a new eligibility criteria, namely that a person shall not be qualified for appointment as presiding officer of the DRT unless he is or has been a district judge. It is submitted that this criteria was introduced by the tribunal, appellate tribunal and other authorities, bracket, qualifications, experience and other conditions of service of members, bracket, rules 2020, dated 12th February 2020. And that by a judgment dated 27th November 2020 of the Supreme Court of India in Writ Petition Civil 804 of 2020, bracket, Madras Bar Association of the Union of India, it has been clarified that the aforementioned 2020 rules would be only prospective in its operation. Paragraph. Okay. Petitioner states that pursuant to an earlier advertisement issued on 3rd September 2019, he had already applied for the very same post where the eligibility criteria was that the applicant, open quotation, is or has been or is qualified to be a district judge, unquote. Consequently, the petitioner questions the fresh advertisement, which disqualifies him, and seeks a mandamus to the opposite parties to consider his pending application pursuant to the advertisement dated 3rd September 2019. We say notice, Mr. Padi accepts notice on behalf of opposite parties and states that he will seek instructions on the current status of the fresh advertisement issued on 12 July 2021, as well as the status of the applications made pursuant to the earlier advertisement dated 3rd September 2019, in light of the judgment dated 27 November 2020 of the Supreme Court of India. List on 7th October.
Lordship, in the meantime, kindly stay operation of the Annexure 8.
We'll consider. List on 7th October. That's why we kept asking you what has happened.
Because Lordship, we have not.
Unless you are clear what has happened, we cannot do
Lordship,
that.
this is a government procedure. How can I know it? I'm an ordinary citizen.
We don't know. So what has happened? Suppose all these applications are simply in the shelf. Nothing has happened. There's no question of
So
stay.
in the apprehension, your Lordship should stay the.
Unless you tell us, sir, unless you tell us what they have done.
Sir, I'm an
pursuant to
ordinary
the-
citizen. How can I know what is
So
happening?
that's
with the
why. So you
government?
have to know and we have to know. All right. Which is why we are asking him to take instructions.
But in the meantime, if they,
Pledged man.
your Lordship, if they in the meantime it proceed with the selection
Anyway,
process.
your
subsequently-
petition is here. We are sitting here. So we'll see what to do. 7th October.
So my IA may be disposed of your for expert stay, your Lordship. Otherwise, the
Yes.
matter will
Item
be
14.
influenced, Lordship.
Item
Kindly
number
dispose it
14.
of this, sir. IA kindly dispose it of, either allow it or dismiss it.
We're just issuing notice on it. Yes.
May I please, your lordship? The petitioners are the street vendors, my lord. So after verification and inquiry, they have granted the certificate as well as the, my lord, identity card. Now they are allotting the kiosk in favor of the others, ignoring these petitioners, my lord, for which they have approached the BMC under Annexure 5 by a representation on 3rd August 2021.
All right. The petitioner's representation dated 3rd August 2021 will be examined by the Commissioner BMC. And after giving the petitioners a hearing, the reasoned order should be passed thereon, not later than 7th December 2021. And copy of the decision should be made available to the petitioners not later than 14th December 2020. The court makes it clear it is not expressed any view on the contentions of the petition. Petition is disposed.
Item 15.
All right. May I please, your lordship? Hearing this case, my lord, the sole prayer of the petitioners are the direction to dispose of the representation by the Annexure 3 at page 20, my lord, pending before the
Please speak to the mic.
My lord. May I please, your lordship? Audible, my lord?
Speak louder.
May I please, your lordship? Here in this case, my lord, the case of the petitioners are that only for a direction to dispose of the representation by Annexure 3 at page
You
20.
have not made these two persons parties.
Yes.
Come to Annexure 3, page 20.
My lord.
You're naming two people,
A
right?
name has already been reflected, my lord, may kindly see.
But you've not made them parties in the petition.
No, so they are the Sarpanch and also the official of the
No, should you
Tahsildar.
not make them parties to the writ petition?
Only for a direct
You're
earlier.
making allegations against them. correct?
Earlier, your lordship directed to name the name of those persons have not been reflected in the representation. To that extent, given a liberty to make a representation by mentioning their names, my lords. Accordingly,
When did you make this representation?
representation made on 25/6/2021. Your lordship disposed on 24/6/21, my lord. Immediately.
What is there to show this was received?
My lord.
What is there to show this was received by the opposite parties?
No, I have not implemented those persons as opposite parties, but I have reflected the name of those persons in the representation by the
Sir, I'm sorry if I've not made my question clear to you.
My lord.
What is there to show that this representation was received by the opposite parties?
That I have. All right, I will take instruction, my lord. Or postal on the from the postal.
How did you send this representation?
My lord. Earlier, I have fed representations without mentioning their names, my
No,
lord.
how did you send this representation either by post or you saw going to their office? Or how did you saw?
I saw by going to their office, my lord.
Then why did you not take acknowledgement?
My lord, to that extent, my lord, I have to take instruction whether that acknowledgement with them or not. I have not.
The counsel of the petitioner is unable to inform the court whether the representation dated 25th June 2021 was in fact handed over to the opposite parties.
Much obliged.
He seeks time to produce the necessary proof thereof.
Much obliged.
List after 4 weeks.
For orders item 16.
Much obliged.
Item number 16.
May I please, Your Honor? Appellant has been convicted. Arrived for a life for the offence under section 302 IPC. So there are two ocular witnesses, Your Lordship.
Is there any paper?
In the meantime, the appellant has been in custody for more than 14 years and 5 months.
Direct eyewitnesses are there.
Yes, Your Lordship. I mentioned before, Your Lordship, there are two eyewitnesses.
Let's read them.
PW 3 and 6.
Yes, let's read them, please.
My lord.
Let's read those two witnesses.
6.
Also,
PW 3 and 6.
PW 3 and 6.
Yes. Paragraph 11, paragraph 12 of the judgment clause.
It's all right. Let's read the witnesses themselves.
My lord.
The occurrence took place. Please read PW3.
My lord, I know the informant, Bhagari Marandi. Similarly, the accused Salhai Marandi, who is standing in the dock, is my uncle. The occurrence took place about 1 year, 6 months back in between 4:30 p.m. to 5 p.m. On the day time of occurrence, I saw the accused Salhai Marandi committed the murder of Dhana Marandi, the deceased, the father of the informant, by means of a paniki, and due to this, there was injuries on his neck, over his shoulder, and other parts of his body. I witnessed the occurrence standing on my courtyard, which is close to in an open place, and there was no wall around at the time of occurrence. As the accused was in angry mode and holding a sharp cutting weapon and apprehending danger to my life, I did not intervene at the time of occurrence. I informed about the incident to the wife of the deceased. Police had inquest over the dead body of the deceased, Dhana Marandi, in my presence and in presence of the other witnesses at the spot, apprehended the inquest report, and I gave my signature thereon. Said inquest report already marked, and this is my signature. Cross.
Cross, you read the cross.
My lord.
There's nothing.
My lord.
No, nothing in the cross that helps you. Now read PW6.
Lordship, in his cross exam, he stated that.
You read it, sir. You read it.
Yes, Lordship. PW6.
PW3 is your own nephew, or must be a cousin, correct?
At a spur of time, there was a quarrel between the deceased and accused. At a
How many injuries?
My lord.
How many injuries?
How
many injuries are there?
Two injuries here. Soldier, two injuries.
Please, no. Please read the injuries. Please read the injuries.
PW 5 was.
Sir, in the criminal matter,
My lord.
you must be clear on facts. All right. When I ask you how many injuries, you should say exactly how many injuries.
Yes, your lord.
5 injuries, you also get it from internal.
Your lordship, there are 4 injuries as per the medical report. As per the
Kindly read PW5.
Yes. Okay. On 8/5/2007, I was working as assistant surgeon, DHH Baripota.
You can leave all that. Come to external injuries.
My lord. External injuries. One inside wound present over the neck, extending below the left ear, posterior to anterior side of the neck, 40 centimeter into 3 centimeter into 4 centimeter. Stretch, not legible, Your Worship. Stretch out completely in the middle. Major vessels like external carotid.
Sir, you are reading this for the first time before us? You never read this before?
No, Your Lordship. The certified copy of the deposition will not legible clearly, Your Lordship.
You are reading as if this is the first time. Somebody is giving you some, in school competition, they will give, no, read a paragraph, like that it is.
No,
You are unfamiliar with this.
My Lord.
Tell me the Roman serial, small numbers are there. How many injuries are there?
There are 5 injuries as per the medical examination.
What did you tell me? When I asked you the question, what did you tell me? What is, how do you benefit by this?
From the initial, I submitted here before, Lordship, there are eyewitness also injuries. Only the.
How does it benefit you, sir, by giving a wrong answer in a matter like this? Are you helping your client?
Only longer period.
You expect that 2 judges will not read the evidence? What is your answer now? You have 2 eyewitnesses, 5 grievous injuries, fatal injuries.
Only 15 years in custody, therefore the appellant before your Lordship.
Yesterday's judgment, Justice Nageshwar Rao, Justice Gavai, they have clarified that life imprisonment means imprisonment for end of life.
And your Lordship consider 15 years in custody.
No, how do you make out your case? We'll consider, unless you make out your case, then how we will consider your case? What is your ground?
So this is not grave sudden, because this man never stopped. He started with the neck. The entire trachea has been cut.
I mean, sharp weapon cut.
Nothing left. All right, we'll pass the judgment. We'll pass. The appeal is dismissed. We'll pass the judgment. All right.
Item number 17.
Item number 17, I am appearing for the opposite party number 1 and 2. I have been served.
Permitted to withdraw, my lords. I am filing the memo, my lords.
All right. The memo is taken on record. The petitioner is permitted to withdraw the petition.
Item 18.
Item 18, both the 2 matters relating to RSCP, I may be pardoned, I will instruct the office to file the recusates. Your Lordship's by the order dated 17th of August, 5th matter to 5th of October. But there was a mistake committed by the office in our office that recusate were not filed. It will be filed by tomorrow.
Has the delay been explained, sir?
Well, here this case, your Lordship will, the huge ramification is involved, and your Lordship will find from the impugned order, that is at page 40, it is mentioned that the voyage has been allowed basing upon the judgment which is under challenge and pending before your Lordship. That's why your Lordship directed there are all the matters to be tagged together and to be heard together.
When is that listed?
Your Lordship directed to matter to be listed on 5th of October. All the matters I have furnished the list.
That list is on 15th October.
Also 5th
October. All right. In the meanwhile, requisites were filed for notice to the opposite parties returnable on the said date. All right.
Item 19.
Item 19, Your Lordship, appearing on behalf of Mr. Sisir Das. Your Lordship, in the last occasion, Your Lordship had directed, after tagging this matter with the second matter, Your Lordship had directed us to serve copy on the counsel appearing for the opposite parties. Your Lordship, we have already served copy. However, Your Lordship had also directed...
We have not received, my lords, we have not received copy.
Lords, I am appearing in the connected matter, my lords. Your Lordship was pleased to issue notice in that on the last order, the learned opposite party number 6, Mr. Pal, who is appearing, was to file rejoinder, my lords.
No, I was supposed to file counter,
My lords.
It is ready, my lords. Just a week time may be given. I will file it. Already it is ready.
All right, Mr. Avijit Pal states that the counter affidavit in writ petition civil PIL
Second matter.
Yeah,
Second matter.
23771 of 2020 is ready and will be filed within 1 week.
My lord.
The rejoinder that too. I'm sure you'll adopt this for the other writ petitions as well.
My lords, my lords. We'll adopt. It's a land acquisition complications.
Yeah, all right. Meanwhile, another copy of writ petition civil PIL 7274 of 2021 be served on Mr. Pal by the counsel appearing for the petitioners in that case. Paragraph. Rejoinder. A copy of the counter affidavit filed in the writ petition civil 23771 of 2020 also be served on counsel for the petitioner in writ petition civil 7274 of 2021. Paragraph. Both sets of petitioners are permitted to file a rejoinder thereto before the next date. We'll take it on 9th November.
Grateful. Grateful.
Grateful.
All right.
Item 21.
Please, your lordship. Here, my lords, the land in question was, my lords, that is, my lords, acquired by my lord the opposite parties, and which was stand recorded in the name of the grandfather of the present petitioner, my lords. And accordingly, my
defects have not been removed. You remove the defects.
My
list after removal of defects.
For admission, item 22.
May I please, your lordship? My lord, here the order passed under Annexus 7 as well as Annexus 4, both are before your lordship on the challenge. Under Annexus 7, the Learned Tribunal.
It's extraordinary, Mr. Mahapatra. It's extraordinary how we were entertaining so liberally all these petitions. What happened was in 2002, you were challenging an order of 1994.
No, my lord.
And the 1994 order, since you did not implement the 1994 order, they had to file a contempt petition. And after the order was passed in the contempt petition, you decided to file a writ petition challenging both the orders in the main matter and the contempt matter.
My lord, kindly see Annexure 1, the 94 order.
Whatever, that was totally innocuous order. All you had to do was to simply consider. So there's nothing wrong in that order.
Yes, my lord. That is what I am saying. Only to consider.
So why should you challenge that order? So why should you challenge that order?
No, 2002, main challenge is 2002 order, contempt order.
Now let's come to the 2002 order.
Annexus 7, page 27.
Yes. Let us read that. It is not a 2002 order, it's a 2001 order, but anyway, read it. It's a 2012-2001 order.
21/1/2002, my lord.
No, it's 2012-2001. Read that order.
Not an advocate for the applicant files a memo stating that as per order of the tribunal regarding the payment of.
That's not the main order anyway. The next one.
That is, next one is the 2002 order.
It is also 2001, please. I don't know why you keep saying this. Anyway, you read it.
My lord. Order of the tribunal has not been complied with by the respondent number 1, despite of specific direction made on 19/10/2001. A copy of which was sent to respondent number 1. A so-called reply has been filed on behalf of the respondent number 1, inter alia stating that the government in school and mass education department have filed 37 SFPs before the Honorable Supreme Court against the order of the tribunal, which is similar with the facts and circumstances of the way in the matter of allowing equal pay for equal work during the period of Shiksha Karmi, which were allowed by the Honorable Apex Court in setting aside the order of the tribunal dated 11/8/1999. The method of appointment of Shiksha Karmi is different to the method of appointment of the regular private school teachers. The order dated as city teacher instead of Shiksha Karmi claims regular scale of pay as regular trained teacher. but the office order dated 6/10/1989 was subsequently modified by the DI of schools by the office order number 6257 dated 19/11/1989. So the payment of equal pay as per the claim of the applicant in view of the judgment of the Honorable Supreme Court does not arise. The prayer of the respondent number 2 is to drop the initiation of the proceeding. On bare perusal of the order sheet, I find that way was disposed of on 20/12/1994, which was modified by the order dated 31/8/1998. The state
95,
respondents
95.
yes,
Please
ma'am.
read
Sorry.
it correctly. 31/8/95.
No, sorry, my lord. The Xerox copy, it's old case, is something is illegible. The state respondents filed MP 335 of 95 for review of the order. The review application was dismissed on 18/4/1996, against which the state respondents did not bother to file SLP or appeal before the High Court, and as such, the order of the tribunal has taken the shape of finality. Since the tribunal directed for payment of salary attached to the post of trained teacher to the applicant, which has been amplified by the tribunal in review application, which has been dismissed on 18/4/1995. 1996. The reply to show cause filed on behalf of the respondent number 1 cannot be taken into consideration at the belated stage. In these premises, let the CP be listed on 4/2/2002 for implementation of the order of the tribunal, and on failure to do so, respondent number 1 shall appear in person.
So you still want to press this writ petition now, despite these facts?
My lord, here, my lord, the tribunal has passed some more direction
You missed
in
the
the
bus on
contempt
so many
proceeding, which was
occasions.
not there in the.
You missed the bus on so many occasions. Why should we interfere at this stage?
My lord, 94 order, your lordship rightly pointed out. There was a direction for consideration.
You fail to do that also, sir. This is the whole problem. You see, you sleep over matters completely. Even in innocuous direction, you do not comply. People are forced to file contempt. This is the whole problem.
Here the problem is, once this claim of the present way is to be upheld, then there will be
The government will shut down. The government will shut down.
No, my lord, there will be multiplication of litigation claiming the benefit
the real
which is
problem,
not
sir.
there by the Honorable Supreme.
You just look at the plight of this employee. From 94, we are today in 2021, right?
Honorable Supreme Court has clarified, my lord, this position. My lord will also find the two office orders, which the advantage of which has been taken by the opposite party.
No advantage, sir. From 1994, we are in 2021. 27 years, not even one single naya paisa has gone to this employee because you've got to stay. You refuse to implement the order of the tribunal. The fact of the matter is this: you refuse to implement the order of the tribunal, despite the employee going back. Review petitions also dismissed by at your instance. No SLP filed. Then the employee has again to go on a contempt petition. When an order is passed in the contempt, you came here, immediately got stay.
Perhaps I have
so
not.
Till now, from 1994 till 2021, till today, that employee has not got even this much of an advantage. For
No, her as regular teacher. She is claiming that teacher scale of pay to be paid.
You slept over it, all right. From 1994, you slept over the matter till a contempt order was passed in 2001, December.
That in the meantime also the review was filed and that was dismissed. So far the period of limitation is concerned, that's right.
You do not even pause for
so much.
27 years of utter frustration.
No, my lord,
And
now
by
she
now that
we are
employee is
also-
retired. By
No,
now
my
that
lord,
employee is
she is
100%
continuing.
retired.
No, she is continuing. I filed an affidavit, my lord.
At least during her service, let her get the benefit of this.
She is in service. Your lordship will.
Very good. At least then, during her service time, she will see justice. Fortunately.
Well, my lord, once she will be allowed to get the.
I know. We'll record a submission that the government will shut down.
No, my lord.
If this employee is giving some 100 rupees, 200 rupees more, your government will shut down.
No, that will be contrary to the honorable Supreme Court decision as I written in
You are
case of
frustrated by your conduct, by not taking action in time. You are frustrated an innocuous order which was in her favor.
My lord, page 29, your lordship will see that judgment of the honorable Supreme Court.
Yes, yes.
Page 29, my lord.
So you do not have to do anything. All right. Whenever you walk into the court, you will get a stay. Whenever you decide to wake up, in whichever matter you wake up, orders can be overturned. Yes.
At least your lordship must have marked, my lord, in so
If you compare the conduct of the government as a litigant and compare it with an ordinary litigant, and we see this every day. See, you are seeing it only as a government counsel, government matters. We see a whole range of matters. The indulgence shown to the state is immeasurable, the kind of indulgence we show all of you. You walked into this court in 2002 against an order of 1994, first day notice and stay. Can you imagine a private litigant getting this kind of indulgence? Can you imagine it? Never. Never. If a private litigant, we are also dealing with private litigants writ petition. Even a delay of 1 year, 2 years, we are not entertaining it. We are saying it is bad for laches. When the government comes in 8 years, 9 years, 10 years, no problem.
No, my lord, at least your lordship must have seen that in all.
See, what has happened as a result, you've never mended your ways. No, Mr. Mahapatra, just see what has happened as a result of all this. Today also, you yourself are unable to defend 3 years delay, 4 years delay, and because you have a bench like this, which is insisting on your explaining, you are unable to explain. Because we were never strict to start with, the government never learned. You took it for granted that 3 years delay, 4 years delay, court will anywhere entertain. It is only recently that the Supreme Court has said enough is enough.
No, my lord, that's right. That is the reason, my lord.
It has just become a habit. Counters never filed in time. Rejoinders never filed in time. Petitions never filed in time. And we are actually speaking for us, if it is a 3-month delay, 4-month delay, even up to 200 days delay, we've been condoning. But that's not the yardstick we use for ordinary litigants. Ordinary litigants, if they come late, they're finished.
That's right. That's right. Here is something different situation.
And you have an entire machinery. See, you're not the only government advocate. You have a whole panel. You have huge departments. We'll pass the detailed order. It's dismissed.
Item 23.
Grateful.
I am appearing on behalf of Mr. P.K. Sahu in this case, madam.
Without
Item 23.
Am I audible, my lord?
Yes, please.
I am appearing on behalf of Mr. P.K. Sahu, appearing for the railways in this case, my lord.
Yes.
The petitioner has already got the leave, not in this case, but from a subsequent date. That is.
So this is infractuous then?
My lord, he is retired also.
All right.
15/4/2003.
So counsel, the petitioner points out that the petitioner got relief.
He's for opposite party.
Oh, you're for the opposite party.
I am for the opposite party.
Who's for the petitioner? Nobody appearing.
In all other times also, he has not appeared.
As I have mentioned morning, a brief has been transferred from my lord, my senior.
No. When was it
Subhash
transferred,
Chandra
sir?
Pushpada.
When was it transferred from? It has been transferred from your senior.
Yes, Lord.
Then why are you bothered?
My name.
Counsel, the petitioner states that the brief has already been taken away by the petitioner. Counsel, the opposite party states that the petitioner has already got relief in some other matter.
No, my lord. He has been subsequently promoted, not in this list, my lord, but he has been subsequently promoted to the same post.
That the petitioner has been subsequently promoted.
No.
In that way, the matter, there's no point in entertaining the present petition, this post of as such.
My presence may be noted.
Item 24.
May I please, your lordship? The petitioner has been preferred this writ application challenging the award of the Learned Labor Code, wherein the Labor Code, Learned Labor Code has not allowing the in reinstatement or any backages. Though in the same footing there are 14 numbers of employees, and out of 14, 6 numbers of employees are awarded 1 lakh in lieu of compensation, my lord. In this case, my lord, what happened then when the management has passed and transferred the petitioner some other department, and that has not been complied as per the ID Act section 9A of ID Act, my lord. And the petition was joining.
So where were you working? First of all, tell us facts properly.
My lord, I am working since 1976, my lord.
As what and where?
In the project division, NHI, as a casual worker since 11/8/1983, my lord. Para 3, page 3, para 3, my lord. My brief, my lord. The present petition, while working under first party management along with other 9 persons since January 1976, all of a sudden they were being transferred to project division Baripada on 11/8/1983.
See, the problem you have is come to para 9 of the award, page 19. You can read that.
Page 19, para 9.
Yes, please.
In the case, hand management has admitted the employment of some of the workmen not on the basis of old registered, like muster roll, paying slip, or attendant register, but merely on the basis of a transfer order which are marked Exhibit 1 and Exhibit B. Both the exhibits reflect that the copies thereof were sent to the person concerned. Exhibit 1 and Exhibit B reflected that the two orders were passed on 10/8/83 on the basis of the order of the Chief Engineer NH and P, Orissa by order number such and such dated 25/7/83. These two orders support to the case of the opposite party that on 10/8/83, 6 of the second party's members are transferred and relieved from the establishment of the first party on 10/8/83 to enable them to join in the project division Baripada. In the claim statement, it is stated that all the second parties member were transferred to the project division Baripada by memo number such and such dated 10/6/83. They have executed the said order as Exhibit 1, wherein the name of only 4 second party members find place. In this evidence, WW number 1 says that the 4 of the second parties member were transferred under written order and the rest were orally directed to report in the new establishment since Exhibit 1, and B reflected that copy of the order was sent to the persons concerned and the second party members whose relationship with the first party has been denied would have produced the order for transfer to prove that they were also transferred to the project division Baripada. It cannot be believed that some of the workmen were transferred under a written order, but the rest were transferred under order instruction, since it is not disputed that a new division was created and employees were transferred from old management to the new management. It cannot be believed that some of the employees would have been transferred orally. These are also the face of the circumstances which discourage this tribunal accept the experience certificate and to raise adverse inference on non-production of the document. Having assessed the material placed before the tribunal along with the attending facts and circumstances, it is to be concluded that the second party members, namely Lata Panda Singh, late Praful Singh, late Sitaram Singh, Sri Laduram Maran, Sri Gora Singh, Sri Samya Murmu, and Sri Gaur Mohan Singh and Sri Jatia Behera were never under the employment of the first party. To that regard, my lord, they have not produced the document as directed by the Law and Labor Code. That has been many of the decisions that the duty of the management to produce the document. When the manager has not been produced the document, I also filed an additional affidavit, the master roll in which I have my name was there. I am getting the salary from the management since 97 to 83, my lord. And see the affidavit I have submitted in the year 2013, my lord. Annexure 2, financial rule form 2 and the master roll in which I am in serial number 1, first Jatia Behera, Samya Murmu, then Ladal Marandi, Panda Singh, and in page 5, my lord, others petitioners there. When the court, Law and Court directed the management, they had not submitted the master roll, the documents, as per the hour, my lord. Kindly see the hour. Page 18, my lord.
Yes.
Middle of the para, with regard to non-production of the documents such as master roll and pay slip from the year 1976 to 1983, the management has taken the plea that the document being very old, it was difficult to trace out them. But how in the Supreme Court decision, my lord, and the decision in 2010 Supreme Court,
how will they produce in the year 2000?
My lord,
how are they going to produce a 1983 document?
My lord,
in the year 2011, because
yes,
the reference was made in 2000, correct?
My lord.
And the award was passed in 2011.
Yes, my lord.
So let us take even year 2000. In the year 2000, how are they supposed to produce a record of 1983?
The record has with us, with the management. The how?
No. How are you expecting them to preserve a 1983 record in 2000 after 17 years?
That record also was. Therefore, we filed the document in shape of
Sir, how can you? It is just your affidavit. How will you substantiate what you have said in the affidavit without there being a record? See, if you do not approach the courts in time, this is what will happen. Evidence will vanish.
In this
and then you are desperately trying to get the courts to agree with your case on the basis of no evidence.
My lord, I have filed the exhibit 2, wherein the experience certificate are there, and they on the ground that
Sir, unless a record is produced, how will they verify it?
Produced before the learned court below. That is the exhibit B, the experience certificate.
Record. Unless you have the original record, how can you verify it?
the duty of the management to.
Where is the duty to keep it for 17 years?
Therefore,
Is there any rule that says they should preserve it forever, all these records?
Year 2010 Supreme Court 1236 mile para 15 miler, it clearly says that applying the principle laid down in this above case, the court, the evidence produced by the appellant has not been consistent. The appellant claimed that the respondent did not work for 240 days and the respondent was working higher at daily wage basis. It is so obvious that the court pointed out the above case that would have difficult to have access to all the official document, muster roll, etc. in connection with his service, my lord. He came forward and deposed. So, in our opinion, the burden of proof shifted to employer, public applicant, to prove that he did not complete 240 days of service in the requisite period. The continuous service. It is the contention of the appellant that the service of the respondent were terminated in 1988. The witnesses produced by the appellant state that the respondent stopped coming to the work from February 1988. The documentary evidence produced by the appellant is contradictory to this fact, as it shows that the respondent was working during February 1989 also. It is also been observed by the High Court that the muster roll for 1986 to 87 was not completely produced. The appellant have inexplicably failed to produce the complete record and muster roll from 1985 to 91, in spite of a direction issued by the London Labour Court to produce the same. In this case, they have not, though rightly directed to produce the original document, though they have with them, they had not been submitted, my lord. And similarly, out of 14 persons, 6 persons are awarded 1 lakh in lieu of compensation. Kindly see page 25, last para, my lord.
Yes.
Of the award. Therefore, the tribunal in favor of the awarding compensation to the workmen in the lieu of their reinstatement and back wages, considering that the workmen had rendered continuous service for a period of more than 7 years. I also continuous service more than 7 years, my lord. And they were refused employment without any valid reason. Only they have grounded that they have not submitted the document prior to before the conciliation machinery, my lord. They are refused employment without any valid reason, for which they have been running from pillar to post for past 27 years. It is considered just and appropriate award compensation of 1 lakh to each of the workmen, namely Chaudhary Mahanta, Sham Singh, Sham Tudu, Mahendra Mahanta, Sukadev Singh, the legal or deceased Meghu Hembram.
Yes, Mr. Counsel.
My lord.
You submit Xerox copies of those two.
My lord, dissents, my lord.
We'll pass the detailed order.
My lord.
Dismissed.
We'll submit the 3 judgment.
Item 25.
My lord, item number 25, I have filed an affidavit on 22/7/2019 by serving a copy on the opposite party. The receipt is available with me also, serving of copy, but it is not available on the record so far as your lordship's record is concerned. And in this case, my lord, they have complied with prayer number 1. I have 3 prayers. Lordship, may kindly turn to the page 7 of my writ petition. Page 7, I have made 3 prayers. Prayer number 1 they have complied with. But so far as 2 and 3 are concerned, They have not done it.
So, madam, when did you file this writ petition?
Writ petition filed in 2011.
And we are today in 2021, correct?
Yes, my lord. In spite of,
In 10 years, what is the position?
my lord, 10 years have been passed, but they have unable to comply with the direction of this honorable court.
No,
So
no.
far as
What is the current position?
current position, my lord, right now I have filed that affidavit. It is not available on record. But
When will it become available on record?
my lord,
When will it become available on record?
my lord, once again I will file, my lord. I have no other option.
All right. Counsel for the petitioner wants to file and further affidavit
By tomorrow.
to bring on record the factual position as at present.
Yes.
List after the additional affidavit is filed. All right.
Obliged.
Item 26. 26, may I please your lordship. This matter related to Sishu Bhavan and earlier occasion, your lordship directed to file an affidavit to the State Council on 29/4/2021 as well as 5/7/2021 regarding the including the drinking water, sanitation and general maintenance of the Sardar Vallabhbhai Postgraduate Institute of Pediatrics, Sishu Bhavan in Cuttack. Order number 26 and 27, lordship kindly see.
So the Superintendent Sishu Bhavan has filed an affidavit today. Do you have a copy?
Yes, well, they have not served the copy, my lord.
So let us have a copy, you examine it. Today, an affidavit filed by the Superintendent of Sishu Bhavan has been handed over in court. A copy thereof be provided to Mr. Budhia.
May I pray, my lord? I am appearing for the petitioner on behalf of the Maitri Sansad. No copy has been served to me, my lord.
Also be another copy also be served on
Mr. Ajay Kumar Mahanti.
Ajay Mahanti, my lord, appearing for the petitioner, Maitri Sansad.
who is Mr. Budhia is amicus curiae, is it?
No, my lord.
Budhia is filing separate writ petition. I am filing. I am
another
filing
copy be served on the Maitri Sansad.
Maitri Sansad.
All right. List on.
Also same prayer, my lord. Sub item 15832. 3 writ petitions are there, my lord.
All right.
2 writ petitions are there.
List on 17th November.
I may be permitted to file a rejoinder, my lord.
Yes.
The counter affidavit filed by the opposite party.
Item 27.
Item 27. I filed this case number
Seniors are going in this case.
2013.
Learned seniors are going in this case. The lordship directed to file an affidavit whether that excise rules is in force or not, my lord.
My lord, that affidavit has not been filed. I am praying for some more adjournment for that purpose.
Why is the lordship directed to file an affidavit?
Yes, that was a direction, but this is the first date. I pray that 2 weeks of time may be granted. On the next date, I will file. This is that the petitioner's prayer to declare Orissa as a dry state. This dispute is this, and
1st November 2021. Transfer to the
Sir.
Rest on 16th level. What are you wanting to intervene about? No, why do you want to intervene? What is that? What are the points which you want to remove? What is it? What is that? So many conditions have been avoided by the state government. That this petition has not been brought those things to do. What are those things? You have to specify what are the things. Your application is very sketchy, sir. Condition. You set it out in your application. You set out properly your application. It's a very sketchy application. And another thing, there are some documents are there that you have to interpret like. So you file a proper intervention application then, not such a casual one. It is available by the record. Instead of 1487. We have that application before us. It's a very sketchy application. Very, very sketchily drafted.
Item 28.
My lord has fixed it to history.
Well, item number 20, and please to your Lordship Miller. Please to your Lordship, my lord, item number 28, my lord. Here, my lord, I am against the order of the Honorable Central Administrative Tribunal that, my lord, the fact is like this, my lord. I was earlier temporarily engaged class 4 employees in the postal department, my lord. And 4 to 5 times I was engaged. Thereafter, from 2014, they have not engaged me in my post. So I approached before the tribunal. The tribunal said,
Mr. Gupta, are you able to hear us?
Yes, my lord, I am.
Your matter has been passed over. Wait.
My lord?
Your matter has been passed over. Please wait.
Passed over?
Yes.
Item 29.
My lord, your lordship may say that the counter copy not served to me, my lord. The noting is there.
Item 29.
My
Paragraph 16 and paragraph 27, 16 onward. And notwithstanding that's right. Say, all right. Who's for the opposite party?
I am appearing for the opposite party.
What do you say?
In fact, my lord, sitting in VC, we are not able to hear from the advocate side because if they are not near the mic, we are not able to hear, my lord. What my lord is in here? Mr. Ray is not totally not audible, and my lord is partly audible.
Mr. Ray, you have to raise your voice now.
If it is near the mic, then pardon, my lord, for putting. I will be post launch. I will be there, my lord. I will be in the
Now the time for completion of the assessment is 6 months from the date of the audit vision report. Now, kindly see on page 17. Page 17 of the order sheet. Order sheet says,
after the expiry of the time limit, I am reading out 29/11/2014.
Yes, Mr. Padil, can you hear her?
Yes, yes. Now it is clear, madam.
29/11/2014.
Yes.
As the assessment could not be completed within the time limit prescribed, that is 6 months after the receipt of the notice for audit assessment, a letter to be sent to the Commissioner of Commercial Taxes. Well, time has expired on 21/11. Then she writes 8 days after. Then Commissioner gives the approval on 17/12/2014 and he completes the assessment. Well, your Lordship's judgment clearly speaks that a post facto approval is no approval. And your Lordship, while following a Supreme Court judgment that is also quoted, your Lordship have quoted that Supreme Court judgment that is in paragraph 27. Paragraph 27, my lords, your Lordship have quoted the importance of the question, power to extend the time is to be exercised before the normal period of the assessment expires. The Supreme Court explained the rationale. Thus, then your Lordship, having quoted that, held that the assessment is not a valid assessment because of the post facto approval, which is, according to this judgment, is no approval. And this is admittedly a post facto approval was given to complete the assessment
beyond the time.
Yes.
Yes, Mr. Padil, now you can reply.
Yes, my lord. The 6 months period was expiring on 21/11/2014. He has sought for extension on 29th, my lord. That's a fact, my lord.
Then that's the end of the matter. So we'll pass the order. In view of this judgment, we'll pass the detailed order. All right.
My Lord Senior raised also the issues regarding 1 year not completed, but it only on these.
I am not there. I am not pressing it.
All right.
Item 30. Item 30, my lord, yesterday we filed the rejoinder. Copy of the same also served on the London Senior Council, Council for the opposite party. We have also have compilation note volume 1 and volume 2. Whether it is got to the court or not, it is not known.
Who's for the opposite parties?
Well, I am for the opposite party, my lord.
Audible, my lord.
My lord, I am for the opposite party, my lord.
He has filed a rejoinder. He says, do you want a copy?
Well, I have already served yesterday. After 5 years, they have filed a rejoinder copy, my lord. After 5 years, my lord, yesterday on 14/9, they have served the copy of the rejoinder, my lord.
All right.
So my simple prayer is, my lord, in this case, my lord, that this opposite party are working as scientists on the central seat board, my lord, and they have given the benefit as per the fifth pay commission report, my lord, to scientists working in Ranchi, my lord. And that has been also allowed by the Ranchi Patna bench. There Jharkhand High Court allowed, Supreme Court also negative, my lord. My little submission is, my lord, when they have given the similar situated person the same benefit, they may granted to on 37/2001. But they have erratically approached on 2006, they have imposed to take this, my lord. My only prayer is, I have already submitted my written note submission by email, my lord, and also the one decision, my lord, that similar situated person may not approach court of law, but they are entitled for the benefit. 37/2001. That is my prayer in the counter and also in the written submission.
Copy. They have submission is submitted. I didn't receive the copy.
What copy?
You have filed the written of submission before the court?
Yes, to you also I have sent on 4th April. My lordship may kindly go through the written submission, my lord. My only prayer is.
Here is the case I am not saying, I am saying. My lord, some order has been passed. That's why I have given 2-volume compilation note.
That is not,
the Supreme Court has allowed some of the scientists and categorically stated that those have not before my lord or before the tribunal. This is not a precedent and that cannot be applicable for all. Phase by phase, all are coming. There is specific page 79, Lordship may see. So, Lordship may keep it after launch or some other day. I will clarify the details.
My submission in 2006, last order kindly similar. I have intimated that all persons similarly situated should be treated similarly, irrespective of the fact that only one person has approached the court, my lord. Even if, my lord, similar situation may not approach the court, they are entitled for benefit. My lord, it is a continued course of action. There are no limitation, my lord. My submission is, my lord.
This is the case
no limitation.
they have approved the Ranchi court and Supreme Court. That's why clarifying. I am just reading, my lord. In our opinion, taking into consideration that the fact that the financial implication on the petitioner organization is too much, too meager. We are not inclined to exercise our power under Article 136 of the Constitution of India to annul and judgments of the order passed by the tribunal and affirmed by the High Court. Accordingly, we dismiss the appeal, leave the petition. However, it is clarified that the judgments in the order passed by the tribunal and affirmed by the High Courts are only in the respect to these scientists who were before the tribunal as applicants and are respondents in the specially application petition, my lord. This was clarified. Now they are coming, the request of the law raised and the question of law raised and argued by C. P.P. Rao, Land Senior Counsel, is kept open to the agitated in the appropriate case. In this conjecture, my lord, what they are claimed and what they are coming for the benefits, it cannot be extended, and the tribunal has ignored the same and passed such order. It is required detailed hearing, my lord. It is because the Ranchi tribunal has passed some order, High Court has some passed order, Supreme Court also pressed the pass the order.
Mr. Padu, he says he has nothing to add other than written submissions. If you want, you also file a written note of submissions. All right. The written note of submissions of the counsel for the respondent is already, opposite parties is already on record. The petitioner is permitted to file written note of submissions within 4 weeks. Orders reserved.
I may be allowed to file further written detail.
All right.
Let them file a copy. Maybe I'll collect from my senior. No issue.
All right. 31.
May I please, your lordship may kindly see the order dated 28/3/2019. The matter has been admitted and this is for final disclosure. Since this has been listed in the supplementary list, I could not prepare the written note. So I pray for accommodation till Monday. In the meantime, I will file the written note as well as the date check.
Who's for the other side?
I am for the other. Till Monday, I pray for an accommodation so that in the meantime, I can file the written note as well as the date check.
The directions has been given to the government authorities to take a policy decision in this matter. And since the employees of the state legal authorities are not getting the benefits as claimed for, since in the other states they are getting the benefits as par with the state government employees matter. Only the direction of the Honorable Tribunal was to government to take a policy decision in this matter.
You're all legal services authority employees.
My lord. Our case is that in spite of several recommendations, and even though in other states their cases has been considered, our case has not been considered.
No, considered meaning what? What has happened in other states?
In other states, they are getting the benefits at par with the state government employees.
Which are the states?
The state of Himachal Pradesh and Andhra Pradesh.
Where else?
This is the recommendation of the member secretary. That is, the recommendation is annexure 4 and 5 before the tribunal. Here is, my lord, the page 28. Page 28 and page 30 is the recommendation. Running page 28 of this read petition, the member secretary have intimated, the Himachal Pradesh State Legal Board authorities intimated to the member secretary of Orissa State Legal Aid and Advice Board in the year 1992. Thereafter, my lord, another recommendation that is annexure 6 of the original application.
No, you mentioned Andhra Pradesh and
Himachal Pradesh, my lord.
No other state have they granted.
My lord, but my specific averments is that in Allahabad also, they have got the benefit.
Where did you know? How do you know that?
That is the averment, my lord, made in the original application. And that has been reflected in the order itself. Page number, in the impugned order, your lordship, page 55. It has been about that in the state like Uttar Pradesh, Haryana, Andhra Pradesh, Karnataka, etc. The legal aid and advice board employees have been declared as government servant by the annexure 4, my lord.
Right.
To that effect, my lord, only a direction has been given to take a policy decision in this matter.
How can that be prejudicial to you, Mr. Mudali, just to consider as a policy decision?
You lordship may call this matter on a Monday because I have not gone through the entire record. You lordship may call this matter Monday so that I can assist my lords in a proper manner. Or tomorrow, you lordship may call this matter. I can.
In fact, you are at liberty to take a policy decision.
No, there is mandamus, my lord.
No, nothing at all.
In fact, you lordship may call this matter tomorrow so that I can assist.
Because the tribunal acknowledges that a policy decision is necessary.
You lordship may call this matter tomorrow so that I can assist my lord.
Because there's already a stay. I don't know why there's a stay granted. All you have to do is just take a policy decision. It's an innocuous direction, Mr. Mudali.
So you lordship may call this matter tomorrow so that I can assist my lords.
We'll pass it over. You come at 2 o'clock. Pass over, 2 o'clock.
You lordship may call this matter as the last matter, man.
All right.
Item 32.
Item 32, I know the first question which will be posed to myself. That is, so far a delay is concerned, my lord.
Yes.
Impugned order is of 2/11/2017 and the writ petition was filed in the month of November 2019.
Right.
In fact, my lord, we have also explained the delay in paragraph 17, but you lordship may kindly see what is the impediment in implementing the order of the tribunal that I have explained in paragraph 8, 13 and 14 of the writ petition. And the service records of the applicant have been seized by a crime branch, by the state crime branch in a police case. Well, that has been, all those seized records are now part of the judicial proceeding before the learned judicial magistrate first class rural Cuttack. Well, that further proceeding of that criminal case has been stayed by this honorable court at the instance of the petitioner. Well, as a result of which the documents have not been released by the learned trial court, as a result of which we are not in a position to complete the disciplinary proceeding against the petitioner, nor we are able to take any.
Why upset the impugned order? You can always, if they file a contempt, you can explain all this. There's no need to set aside the impugned order for that. You said the challenge is the present petition.
The lordship may only observe our predicament that we have stated at paragraph 8, 13 and 14.
This GR case is 1990.
Yes, my lord.
How can you keep waiting for 30 years, please?
Well, it is stayed at the instance of the petitioner. And that order also we have enclosed. That order, my lord, we can get it.
No, but you can always go and get it vacated. You have to take steps for that. You can't simply sit and say, I will not implement. You could have easily filed an application to vacate that stay. Yeah, Asian reefer surfacing also. This is not an impediment anymore, Mr. Mudali. You say the challenge, the present petition is to an order dated. 2nd November
I was
2017 passed by the
that
Orissa
another
Administrative Tribunal.
may I
OAT.
submit one thing, my lord? Well, I was verifying that another writ petition is also pending against the self-same order. Page 3, my lord, may kindly see.
Okay, that will pass the same order as we are passing this. Order dated 2nd November 2017 in OA number 1078 bracket C of 2016. The present petition was filed only on 16th November 2019. Paragraph in seeking to explain the delay in filing the present petition, which is stated in para 17 is under. Paragraph, the above narration indicates that although the order was available to the petitioners on 23rd November 2017 itself, the intimation to petition number 1 by petition number 2 for taking further course of action was sent only on 23/2/2019, that is more than 1 year and 3 months thereafter. This inordinate delay in even taking the first step is not explained. Paragraph, thereafter between 23rd February 2019 and the date of filing the petition, that is 16/11/2019, the reasons are purely administrative in nature. Paragraph, the above explanation is not at all satisfactory. The Supreme Court has then set out. Paragraph. Mr. Mudli tried to submit on merits that the impugn order was difficult to implement because of some stay granted in criminal MC number no, stay granted of the proceedings in GR case number 196 of 1990 by a stay granted in criminal MC number 1258 of 2008 in this court. If the petitioner was so minded, it could have easily moved the court to vacate the stay. In other words, the above was really not an impediment if the petitioner was serious about implementing the impugned order of the OAT. For the aforementioned reasons, the court finds no reasons to interfere. The petition is dismissed.
Item 33.
I'm a pleasure, Lordship. Lordship, here in this case, we need to file a rejoinder, my lord. And case law, we have made certain researches, and case laws are necessary because the OSRP rule, iris of the OSRP rule is challenged here in this case, military application, my lord. 2 weeks time may kindly be granted to file a rejoinder, my lord. Detailed rejoinder.
Actually, in the meantime, what has happened, my lord, I'm appearing for the connected WPC 32414 of 2020. Here, what has happened, they have challenged the basic grade, actually, of 2,800, they are saying it should be 4,200. But similarly, persons, those who have retired, they have already accepted that 2,800 and the revised scale of pay has been fixed against them. Against on same category of persons, employees, but in different judicial districts of Orissa.
Anyway, counsel for the petitioner seeks and is granted time to file rejoinder within 4 weeks. Interim order to continue list after 8 weeks.
Item 35.
Obliged.
Item 35.
The Advocate General will address my lords. We have filed the rejoinder. We have complied with the last order. We filed the rejoinder.
35.
Sir.
34. My lord, 34.
The adjourned to 80 chapter.
May I submit, my lord, in item 33?
Yes, please.
My lord, in
It is over. 33 is over.
It's 35 now.
My name is wrongly reflected in the list, my lord.
All right.
My lord, item 35 is that matter, my lord, that contempt matter.
Right.
I think your Mr. Tripathi was appearing and your lordships have listed it at 2 p.m. If your lordships want, my lord, I'll...
No, we can take it up at 2.
Yes, yes.
Special bench.
Hello, item 36, my lord.
36 already adjourned.
Already adjourned.
Then my presence may kindly noted, my lord.
All right. All right.
36 and 39.
Yes, yes. No, we continue after lunch. We'll continue after lunch.
Item 37.
Mudali?
Please, your lordship.
Item number 37.
37. I'm for the opposite party. my lord.
Let Mr. Mudali appear.
So 37 records have been assigned to Mr. Sahu. Probably he has not joined. Your lordship, kindly pass it.
But 35, your lordships have to take up at.
I know. We'll just finish a small.
Lordship, please. Lordship, please.
Yes, Mr. Mudali.
No, Mr. Records have been assigned to Mr. Sahu, my lord. Am I audible, my lord?
Yes, yes. Where is Mr. Sahu?
Probably he has not joined. I am requesting him to join. Your lordship, kindly pass it out.
All right.
Item 38. 37 pass.
Item 38, my lord, I am appearing for the opposite but not 2. So may I request to allow me 4 weeks time to file my counter in detailed counter, because this is a matter where the petitioner is challenging the order of London Tribunal, Central Administrative Tribunal, but the no original application, copy of the original application as well as the counter has not been filed by the petitioner in this petition.
All right. Whom are you for?
But I am for OP number 2, my lord.
All right. Counsel appearing for OP number 2 prays for and is granted 4 weeks to file a reply. Rejoined for the next date. List after 12 weeks.
Item 40.
Already adjourned.
Same matter.
Item 41. Two. 42.
Mr. Padi? No, only with state of Orissa. Yes. He's appearing last month. He said none appears. The petition in the interest of justice list on. List after 8 weeks. All right.
You can pass over petition. Item 28.
Please to your Lordship Millard. Here I am for the petitioner Millard. The case is that, my lord, I am against the order of the Honorable Central Administrative Tribunal. Fact is that, my lord, I was appointed a temporary class 4 post in the postal department since 1996, my lord. Up to 2012, I was engaged frequently at temporary basis, my lord. Thereafter, they have not given the work. So I came with earlier I filed before the Honorable Tribunal. Tribunal dismissed my case. Lawsuit turned to page number. Lawsuit turned to page 20. Page 20, my case was dismissed. Because in their counter there, they say that is a ban order. After the ban order, thereafter the recruitment will be held and your candidature will be considered, my lord. But in RTI, my lord, I collected the document from the RTI by annexure 5, page 14. It was stated that the vacancies are there, my lord. According to that, my lord, I have also filed one miscase in this case. That is miscase number 2925 of 2021. In para 3 of my miscase, I have stated that at present also, in this case, notices already, in the meanwhile, some class 4 post of GDS, MTS is lying vacant. So I filed my representation by the annexure 10 series is pending before the opposite party number 2, senior superintendent. So your lordship, my humble submission and prayer, my lord, your lordship direct the OP number 2 superintendent to consider my representation by the annexure 10 series on the basis of annexure 4, my lord. Question of the vacancy position, my lord. That is my only prayer, my lord. The very small case, and that person is unemployed now and overage. So he will not get.
If he's overaged, then what's the point?
My lord?
If he's overaged, what's the point?
That overage, my age is now.
So anyway, he can't get it.
14, it was 31. So 7 years already gone. So there is no service. So my only submission before your lordship, my lord, your lordship direct the OP number 2, that is senior superintendent, to consider my representation by the annexure 10 series. As I attach in the
Overage is 38 now. How can you get a point?
Yes, Mr. Gupta.
My lord.
If you are overaged.
But I was continuing earlier as per my earlier.
No, listen.
I was continuing there.
If you
I
are
am not the fresh candidate, my lord. I am not the fresh candidate.
Listen, kindly listen.
Earlier,
kindly listen. If you are now overaged, then how a direction can be issued for your appointment?
Because, my lord, I was continuing in my post, my lord.
No.
From 96, I was continuing. My lord, from 96, I was continuing up to 2012. They engaged me further, my lord, on that post. So 96 to 2012, I have served before OP number 2, my lord. This is a temporary post. And that post is also available there. So I am not a new fresh candidate, my lord. Earlier I was working 96 to 2012, my lord. 16 years service before in that postal department. So engagement.
What is the wrong?
My lord, another thing, my lord, is the case of 2014, my lord.
What is the wrong in the impugned order of the CAT?
Impugned order, my lord, they say that though this is the ban order, it is not possible. According to that, we are dismissed. But in RTI Annexure 4, got that ban order is now that is there is an counter also. You also may kindly see their counter page 8 para 11, my lord. Page 8 para 11. They have also filed and admitted.
There is a direction there is a direction in your favor that your application shall be considered for future vacancies.
But they have not considered that.
Then that's a different.
I have to say, stating by the through RTI that vacancy is there, and also in the miscase also I have stated that vacancy is available op number 2, and in the counter para.
That's a different cause of action, Mr. Gupta. That's a different.
No, I am coming, my lord. I may be permitted to submit on page 8 of their counter para 11.
No, see, listen. Your challenge is order dated. Your challenge before the CAT is order dated 27 June 2013.
My lord.
In that order, they have said that whenever a future vacancy will arise, your case shall be considered in pursuant to the direction of this court.
Yes, my lord.
So what is that? What is wrong? If there is any future vacancy arising,
they dismissed that, my lord. The question is that they party.
That's why they dismissed.
So according to a dismissal order, I came and I submitted that annexure 5 page 14. The RTI, I collected the information from RTI, the post is vacancy. And here also kindly turn to annex page 8 of their counter. Para 11, second sub para 2 mile. They have stated that the in future my candidature will be considered. Counter also they have stated in before your lordship, my lord. In counter, I am coming to that, my lord, page 8 of the counter. Page 11, my lord, your lordship kindly page 7 para 11 sub para 2. His candidature will be duly considered along with the other candidates for the future vacancies of GDS for the same in response of notification strictly in accordance with law. So when they have stated that in future my candidate will be considered, so that annexure 10 series is pending before you. I filed the application.
Nothing wrong with the order.
So my only submission before your lordship, my lord, your lordship direct the op number 2 to consider my
direction is that's all over. Several rounds are over already.
I know.
Several rounds of litigation is over now on this. All right. This is the third round of litigation concerning the petitioner's claim for regular employment with the Office of the Superintendent of Post Offices, Cuttack, where he was temporarily engaged by the postmaster, Baravati Stadium, SO, for supplying water to the staff. Paragraph. Initially, the petitioner had filed OA number 594 of 2006 before the Central Administrative Tribunal, Cuttack bench, Cuttack, bracket CAT, with a prayer for appointment against any post of GDSMC in that division. On 28th August 2006, the CAT disposed of the application with the direction that the petitioner's case would be considered on merits in accordance with the rules. Paragraph. Thereafter, CP number 1 of 2007 was filed when the above order was not implemented. On 1st July 2008, an order was passed by the opposite parties, taking into account the petitioner's candidature for different GDS posts for which selection / recruitment was made. However, the petitioner was not meritorious in the said selection when compared to other candidates. Paragraph. The second round, the petitioner filed petition civil 16551 of 2008 for a prayer to appoint him in any MTS / GDS Packer -MC vacancy. On 2nd March 2009, the said petition was disposed of with this court with the observation that open quotation, as soon as the ban is lifted, the case of the petitioner will be considered giving effect to the order of the tribunal as aforesaid. Unquote. Paragraph. Alleging non-compliance with the above order, the petitioner filed contempt case number 916 of 2010. Stop. This was disposed of by this court on 1st May 2013 with the direction that, open quotation, if the recruitment process is initiated for filling up of the MTS or big GDS packer MC vacancies, the petitioner will be granted liberty to make an application and the case of the petitioner shall be considered, if he is otherwise found eligible. Unquote. Paragraph. Thereafter, the petitioner made a representation dated 20 June 2013, requesting that he be appointed in any post in the Cuttack City Division. By letter dated 27th June 2013, the opposite parties informed the petitioner that his candidature would be duly considered along with other candidates for future MTS or GDS packer MC vacancies in the division if the petitioner applied pursuant to the notification, strictly in accordance with the rules and recruitment procedure in force of that time. All the recruiting units of the division were also instructed to consider the petitioner's case accordingly if he applied for any post in response to the notification. Paragraph. For some reason, unhappy with the above order, the petitioner filed for the third time OA number 937 of 2013 in the CAT, praying for caution of that said order. The CAT has, for the impugned order dated 28 January 2014, held that the order dated 27 June 2013 of the opposite parties was perfectly valid and has dismissed the petitioner's OA. In response to the present petition, it is pointed out by the opposite parties that the petitioner was not a regularly appointed employee. He was temporarily engaged for supplying water to the staff of the Baravati Stadium SO and had been paid from the contingent of the establishment. His candidature was duly considered for different posts as and when recruitment was made, but he could not qualify on merit. Accordingly, it's prayed that there has been no violation of any of the orders passed either by the CAT or by this court. Paragraph. Third, counsel for the petitioner refers to an IA number 2925 to 2021 filed by the petitioner, stating that through the RTI Act, he has obtained information of the vacancies in the division. He submits that although he is overaged, that is currently is 38 years old, his representation made to the Assistant Superintendent of Post Office, Cuttack Division, Cuttack, on should be favorably considered. Paragraph, the court is unable to agree with the above submission. There have been numerous orders already passed on the petitioner's prayers from time to time, both by the CAT as well as this court. It appears that the opposite parties have indeed complied with those directions and have considered the case of the petitioner for appointment on a regular basis in the vacant posts as and when they arose. As and when the vacancies arose, no further directions are warranted. The court is unable to find any ground made out for interference with the imputed order of the CAT. The prayer made in the application can also not be granted since clearly the petitioner is overreached. The petition is accordingly disposed of.
Lordship may reflect the Cuttack City Division.
Hello.
It is
No, annexure 10C, I have my application on 15/9/2014 to the Assistant Superintendent Post, Jagatsinghpur Subdivision. That is under the
Item 31, sir. Past door matter, item 31.
Yeah, please, your lordship. Here, may I please, your lordship. Well, here there are 2 points involved. Well, the first point is the tribunal, being a creature of the Administrative Tribunal Act, is denuded of any power to direct the state government to frame a policy in a particular manner. And for the sake of argument,
there's nothing like that, please.
Yes.
It's quite an innocuous direction.
No, there is no innocuous direction. I would place that paragraph. And even if it is accepted that the tribunal is competent to pass such a direction to the state government to frame a particular policy, even if that finding of the land tribunal is erroneous on the face of it, you will also kindly turn to the impugned order at page, that is annexure 3 at page 53. My lord, may kindly turn to page 6, running page 68, internal page 6 of the tribunal's order. I am placing from paragraph 6. May I place, my lord?
Yes, yes.
The points to be decided whether the applicants are entitled to pay as is applicable to government servants from the date of their joining in the board, from the date of their appointment, that is 1/12/1983 and 12/1/1982 respectively, and grant them all financial and service benefits of the government servants on the principle of equal pay for equal work, to grant them arrear salary with reference to pay from 1/1/1996. The applicants were initially engaged early 1980 as at Annexure 1 by the then Orissa Legal Aid and Advice Board as NE Recruitees. This board was a non-statutory board, and how the applicants were requited and what was the basis of their claim to be entitled to the salary of government servant has not been brought out. You will also kindly mark this person. Paragraph 7. During the course of argument, learned counsel for the applicant submitted that this case is squarely covered as per the decision of the Apex Court in the case of Maharashtra Direct Equipment Class 2 Engineers Others Association. Thus, decision of the Honorable Apex Court reported in AIN 90 SC 1607. The decision of the Honorable Apex Court in that case has been summarized at para 44 of the judgment, seems to have some connection that with the present issue. At para 44b, it is brought out, if the initial appointment is not made by following the procedure laid down by rules, but the appointee is continuing the post uninterruptedly till the regulation of his service in accordance with rule, the period of officiating service shall be requisitioned. However, however, as brought out in the counter and as argued by the Land Standing Council, the applicants were non-government employees appointed by non-statutory body on a monthly remuneration basis in the Office of Legal Aid and Advice Board. Nowhere respondent number 1 at that stage followed any rule or instruction for such recruitment. The Orissa Legal Aid and Advice Program 1989-81 was dissolved by the respondent number 1 in their notification dated 1/2/1997 at Annexure B after constitution of Orissa State Legal Services Authority for the state under the provisions of Orissa Legal Services Act 1987. Upon such dissolution, the erstwhile employees of the board who are working preceding 1997 ceased to continue as such. Only services of those among them who are found suitable were absorbed in OSL SA after its constitution. Hence, it is not a question of ad hoc appointment leading to regulation. This is fresh appointment. Any right of regulation that will accrue to them will have to be on the basis of rules or policy decision. Accordingly, their cases were examined and the resolution by the annexure A was passed. As regards principle of equal pay for equal work in the case of so and so, wherein the Honorable Apex Court observed as follows: when services of the respondents have not been regularized, his appointment was on temporary basis on consolidated pay, and he has not undergone the process of regular appointment. Direction to give regular scale of pay could not be given, that too without examining the relevant factors to apply the principles of.
What are they currently getting?
Well, now they are in the government fold.
No, the government fold. What is the actual pay that they are getting?
Well, that instruction, because that was not the subject matter, because they have been taken as the government employees since 19.
No. So is there plea that the previous service in the board should be counted for a pension? Is that the plea?
Yeah, their claim is that, but there is a government policy which was never challenged.
No, what is their exact plea? Tell us.
Yes, their claim is that they should be given regularization from the date of initial appointment.
No, there's no question of regularization, right? Because they're not, right now, they're not temporary or ad hoc.
No, you Lordship,
they were freshly appointed in the Legal Services Authority, correct?
Yes.
So what is their prayer?
Page 20, my Lord, my kind says prayer made in the way.
Period of service when they did not
direct the respondent to regularize his services from the date of his joining, to direct the respondent to grant equal pay for equal work, to grant all benefits attached to the post from date of joining, to direct the respondent to include past services of the applicants and consider their case for higher promotion, to grant DA and house rent from 1991, to direct the respondent to grant the benefits of revised scale of pay from one.
No, the last one, for instance, revised pay scale from 1196. What is the problem in granting that? If they're already part of the government.
You Lordship, may kind turn to page 46. That is the policy decision of the government, and that was never challenged by the present petitioners, present applicants. Running page 46. That is the notification of dated 28th of January 1997. And by this policy decision, government abolished that board, and this is the third subparagraph. Now, therefore, the state government have been pleased to resign the said notifications of the government along with the aforesaid program and scheme, save as respects things done or actions taken thereunder with immediate effect, and direct that the Orissa Legal Aid and Advice Board constituted by the government under the said program shall stand dissolved.
No, let's see the last E, the employees of the board.
E, the employees of the board who continue therein on the date of immediately preceding the date of publication of this notification in the Orissa Gazette shall cease to so continue. Shall cease to so continue unless such employees, except those who have completed the age of 58 years, are suitably absorbed by or under the orders of the state authority in any of the authorities or committees constituted under the said act and the rules framed. Well, after this notification, they were found fit and they were given fresh appointment from 1997. That finding, your Lordship, may kind down to page 60, running page 61. And this paragraph 8, that I was placing, your Lordship, and next page 61, last 4 lines from the top, my lord. In the case at hand.
Yes.
In the case at hand, the applicants were recruited by a non-statutory body which was dissolved, and thereafter they were freshly taken as government service. So they were taken as government service, but they were considered as government service since after 1997. Now, my lord, we can into paragraph 10. Be that as it may, considering the submission and the materials placed as discussed above, as the appointments of the applicants is continuous. In paragraph 8, the land tribunal came to the conclusion that they are giving fresh appointment. Now, in paragraph 10, the tribunal observes that their appointment of the applicants is continuous in service.
No, continuous means from 1197 they've been continuing, please.
Continuous means they are referring to the old.
No.
After 1997, they have not been.
What are they claiming from 83? It's not clear at all. let us hear the opposite side.
May it please, my lord.
What are you actually praying?
My lord, I am praying the benefit of DA, house rent allowances and other benefit from 97 itself, my lord.
No, when did you come to claim this? When did you claim this?
I claimed this I filed this original application in 2002, my lord.
So you're coming after 5 years?
My lord, in spite of several representations and recommendations made by
will not give you all that.
My lord, the recommendations has been made by the member secretary, my lord, time and again, my lord. In spite of that, the benefit has not been given.
No, it's only a recommendation, please.
My lord.
There is no order granting you all that.
There is no order itself, my lord.
So you are as it is belated before the tribunal.
No, my lord,
that is 2009.
My lord, the order itself in annexure 9, my lord. This was the 2002 order. 2 order has been passed, my lord. Your lordship may see the running page. In the original application, annexure 9, my lord. They have given, my lord, in the original application, in this writ petition. Your lordship may see the page 42, running page 42, my lord. This prayer has been rejected in 2002, my lord, in the month of February 2002.
Then you waited till 2009.
No, my lord, I filed this original application, my lord, in 2002. It was numbered as PP. My lord, it was permission petition since more than one applicant. My lord, it was renumbered as OA number 2800 in 2009, my lord. But it was filed in 2002. That is PP number 217 of 2002. That is, this application has been filed, original application filed on 7/7/2002, my lord.
Is your only grievance about the CPF?
No, not my lord. They have granted
this
the
order of
CPF.
2002 is only on that limited aspect.
My lord.
Our prayer has... You can't just expand it. Your limited prayer is only this. Just let's come to this annexure A.
My lord.
The resolution of February 2002 of the government.
My lord.
It's on a very limited aspect.
They have considered. They have considered.
Employee did not subscribe to CPF, even though he was eligible or ineligible to subscribe, shall not count for pension.
My lord.
And where the employee has withdrawn his accumulation CPF along with the employer's share, such spell of share of service shall not count for pension. There is no other prayer at all.
No, your lordship, please come to the kindly be page 56 of the impun order, internal page 4. After a considerable time, my lord, it starts from internal page 4 of the impun order, running page 56. After a considerable time, the applicants were declared as government servant with effect from 1/2/1992 by Law Department notification dated 28/1/97. Their service were regularized with effect from.
That year is probably wrong, my lord. 1992 probably is wrong.
That is 97, my lord. Their service were regularized without any financial benefit basing on the contribution of CPF, my lord.
Correct.
Since it has become a government department, the employees are obliged to deduct CPF from their debt when the employees entered into government service, which has not been done. Respondent number 1 has been pleaded and granted the following reliefs, so and so. My lord, our contention before the tribunal is that since
we have the entire scope, 1 minute. So let us understand the entire scope of the petition was just this, nothing more. This was the only issue before the tribunal, correct?
My lord.
So let's first of all be clear on that. What is wrong in their denying you when you did not even subscribe to CPF? How can that count for pension? It cannot.
No, my lord. The page 61, as regards prayer for page 61, running page 61, paragraph 9, as regards prayer for granting pensionary benefit, no rule has been cited. That means, my lord, no rule has been framed till date, my lord. That's why the Honorable Tribunal directed to take a policy decision to the government, my lord.
No. As far as this player is concerned, there's no question of counting past service. You came into service only from 1997.
My lord.
And in 2002, when you came to the tribunal, your only grievance was about CPF and counting for pension. That's all.
My lord.
Nothing else. Nothing else.
The period, my lord, the question is that the period of service during which the employee did
They have
not
already
subscribe.
taken a decision. So this is the policy decision of the government. Whatever is there set out in para 9,
My lord.
that is the decision of the government.
That is page 42, ma'am.
What is wrong in that decision of the government?
No decision has been taken, my lord. No decision has
What
been.
is wrong? I'm saying once a decision is taken on 28th February 2002, there's no question of again framing a policy. They've already taken a decision.
This is 28/2/2002 is the rejection order, my lord. My representation.
Correct. So where's the question of now framing a policy? Once they have taken a decision and they've rejected your prayer, where's the question of again a policy?
So far as our prayer is concerned, my lord, in all other states, my lord, they are getting the benefits at par with the state government employees, my lord.
Here also you're a state government employee only. You're a state government employee from 97.
97.
What is not your prayer here, please? That's why I kept asking you, what was your prayer?
But without any financial benefit, my lord. We are not getting.
From the date you became a government employee, you have financial benefit.
We are not getting the financial benefit at par with the state government employees from 97, my lord.
What is the financial benefit you're not getting?
Financial, my lord, the pension, my lord.
When you are in service, how will you get pension?
My lord, I have already been retired, my lord. This petitioner already been retired, my lord.
When did you retire?
In 2011, my lord, he retired.
No. So when you filed it, there was no question of pension in 2002.
My lord,
this is a continuation of the 2002 petition, correct?
My lord. My lord, the dearness allowances has not been given. The house rent has not been given.
No, but not like this. Have you actually made a quantification of what you have not been given? See, in 2002, you were very much in service.
My lord.
The prayer was not, if you go back to the resolution of 2002, the prayer was not about HRA and all of that.
My lord.
And the prayer was not that what benefits given to other government servants are not given to me. The prayer is very limited about counting your past service for the purposes of pension.
My lord.
See, the scope of this petition was very limited.
My lord.
You see, the state of Orissa has filed this petition against an order dated 4th January 2016, passed by the Orissa Administrative Tribunal in OA number 2800-C of 2009, filed by opposite parties 1 and 2. By the impugned order, the OAT has directed the petitioner state has stated that the petitioner state is at liberty, open quotation, to take a policy decision to extend the service and financial benefits as claimed for by the applicants, as is available to their counterparts, and such action be taken within a period of 3 months from the date of receipt of the copy of this order, unquote. Paragraph. Having heard learned counsel for the parties, it appears to the court there is no clarity on what the scope of the OA was. Paragraph. The aforementioned OA appears to have been filed originally in 2002 against a resolution dated 28th February 2002 of the government in response to the prayer of the opposite parties 1 and 2 and others similarly placed who had been the erstwhile employees of the Orissa Legal Aid and Advice Board (OLAB), who upon the constitution of the Orissa State Legal Services Authority came to be appointed in the new establishment, which is under the law department of the government with effect from 1st February 1997. These appointments were under the provisions of the Legal Services Authorities Act 1987. Paragraph. At the stage when the opposite parties 1 and 2 approached the OIT, the grievance was in a limited sphere. Stop claiming that the period during which they had served in the OLAAB should also count for the purposes of their pension. They had been representing to the state government. This was in fact rejected by the aforementioned resolution dated 28 February 2002 on the following grounds. Take 1 and 2 from para 9, page 60. Sorry, page 57, no 1 minute. Page 61, para 9. In the impugned order, the OIT correctly notes that the appointment of the opposite parties 1 and 2 with the government was in fact a fresh appointment. As far as counting the past service is concerned, clearly that could not be in the absence of a policy decision of the state government. Stop. However, there is no question of directing the government to formulate a policy when the decision was unambiguous. The decision as spelled out in the resolution dated 28 February 2002 was unambiguous. Paragraph. A careful scrutiny of the two reasons given shows that they do not suffer from any illegality, particularly since a person cannot be claimed to be eligible for pension when he did not even subscribe to the CPF in the first place. Full stop. Further, if an employee had withdrawn his accumulation in CPF along with the employee's share, then the period of service cannot count for pension unless he had refunded to the government the employer's contribution with simple interest as mandated. The court is unable to find anything erroneous in the said policy decision. Full stop. Paragraph. Counsel of the opposite parties 1 and 2 then urged that they had in fact not been paid HRA and other financial benefits on par with the state government employees. Full stop. That, however, does not appear to be the scope of the OA as it was filed in 2002 for the OAT and then renumbered in 2009. Full stop. The court at this stage is not prepared to expand the scope of the proceedings for the OAT. Paragraph. As far as the mandamus issued by the OAT is concerned, a direction to the government to now frame a policy on the above issue was not warranted, since the decision as expressed in the resolution dated 28 February 2002 was unambiguous. The said direction is accordingly hereby set aside. The petition is disposed of in the above terms. No order is to cause.
Item 35.
May it please, Your Lordship.
May I be permitted to submit a lordship?
Item 35.
May I be permitted to submit, Your Lordship?
My lord, am I audible?
Yes, please.
My lord, this is kindly come to page 22, my lord, the reliefs in the writ appeal. If my lords have page 22, my lord.
Yes.
Your lordship will see, my lord, the reference to 5 orders. That 16th April order, I have not pressed. That your lordships have noted in the order itself.
Yes.
Yes. Well, and now all the three are orders arising out of contempt proceedings. I have given your lordships a memo, a compilation, which was there on the last date when my lordship used to issue notice and pass interim orders on 19th May 2021. Does the lordships have it?
One minute. Here's a compilation.
It is called a memorandum. The lordships have referred to it in the first order itself. It is 19th May 2021.
Yes, that's true.
It has a list of dates.
Actually, next time, when they scan a paper, you should put a stamp scanned. Yes. What page of that compilation?
And now, my lord, your lordship may kindly see that the first submission was regarding maintainability of the writ appeals, which Mr. Tripathi had opposed, and your lordships had said it will be considered first.
Yes.
Now, kindly turn to, my lords, page 152. This is Midnapur People's Cooperative Bank Limited and others.
Right.
And if my lords will be pleased to kindly turn to page 163 minutes. Paragraph 11 is what I had relied upon. It is page 1. Yes. The position emerging from these decisions in regard to appeals against orders in contempt proceedings may be summarized thus. Your lordship may skip over 1 minute. Kindly come to the next page, Roman 5.
Yes.
If the High Court, for whatsoever reason, decides to issue or makes any direction relating to the merits of the dispute between the parties in a contempt proceeding, the aggrieved person is not without remedy. Such an order is open to challenge in an intra-court appeal if the order was of a learned single judge and there is a provision for intra-court appeal, or by seeking a special leave to appeal under Article 136 of the Constitution of India.
Right.
And my lord, if your lordships now kindly turn to page 167. Paragraph 16 is what I relied upon. Paragraph 15, if your lordship sees interim orders, my lords have it, my lords, page 166.
Yes.
Interim orders, interlocutory orders passed during pendency of a case fall under one or the other of the following categories. Orders which finally decide a question or an issue in a controversy in the main case. This is what I am relying upon, lords. And the other is kindly see Roman 3, orders which finally decided collateral issues or a question which is not the subject matter of the main case. And now kindly see paragraph 16. The term judgment occurring in clause 15 of latest patent will take into its fold not only the judgments as defined under section 29 CPC and orders enumerated under so and so, but also other orders which they may not finally and conclusively determine the rights of the parties with regard to all the matters in controversy may have finality in regard to some collateral matter which will affect the vital and valuable rights and obligations of parties. Interlocutory orders which fall under category 1 and 3 above are therefore judgments for the purpose of filing appeals under the latest patent. On the other hand, orders falling under the other categories. But I am concerned with 1 and 3. Now, in the counter which has been filed by my learned friend, my lords, if your lordships take the counter affidavit, he is relied on 2 judgments. The first one your lordships will get, my lords, at page 54 of his counter. So I will first deal with maintainability, and then I will come to minutes. If your lordships have the counter affidavit, kindly turn to page 54. My lordships have page 54, my lord.
1 minute. Where's the counter? Let's scan it.
Filed on 9th of August, 2021.
What's the continuing page? You have the Is there a continuing page number?
That's my lords have the counter affidavit.
No. Give us the continuous page number, please. The paper book number. Page number in the paper book. Mr. Tripathi, do you have it?
Yes, I have it.
No, the continuing page number.
No, I have an extra set if I can hand it over.
You have to speak louder. You have to speak into the mic.
I have an extra set. Can I hand it?
No. Please tell us this. In the paper book, what is the page number?
It could be 110. 110, it could be minus.
You have to check all this. When they prepare a soft copy of the cause list and this, you have to check in these matters whether all pages are
100, it could be 100.
In the morning when you come, you have to check. No, they've not numbered it continuously page number. What? In this counter, have you got it? We've got the counter affidavit. So can you tell us the page number?
Internal page 54, my lord. This is DN Taneja versus Bhajanlal. My lords have it.
Right.
My lord, this was a case where an appeal was filed under section 19(1) of the Contempts of Court Act.
Right.
And your lordship may kindly see page 57.
Right.
Mr. Sibbal Learned Counsel, appearing on behalf of the respondent, has taken a preliminary objection to the maintainability of appeal under 19(1) of the Act. It is contended by him that as no punishment was imposed on the respondent by the High Court in exercise of his jurisdiction to punish for contempt, section 19(1) is inapplicable and the appeal is incompetent. Then, my lord, they quote the provision, the right of appeal will be available under subsection 1 of section 19 only against a decision or order of the High Court passed in excise jurisdiction to punish for contempt. So therefore, my submission to your Lordship, my lord, I have not filed an application under 19(1) of the contempt court of that.
Right.
And therefore, this is a letter patent appeal and not an appeal under the 91, under section 19(1). And therefore, my lords, in my humble submission, this judgment is clearly distinguishable.
Right.
The second judgment is at page 60. This is Khode Distilleries. And the point is regarding merger of orders passed by superior courts. That is what my learned friend seeks to argue, my lords. The relevant page is 66, paragraph 19. My lords have it, my lords.
Yes.
My lord, in my humble submission, there was no order passed by the Honorable Supreme Court which would result in the principle of merger being applicable to this case. These are the two citations which my learned friend has cited on the maintainability of this case.
Right.
Now, would your lordship see the case on merits? Would your lordship see page 83 of that compilation?
Yes.
If your lordship sees page 82, I'm sorry, page 82.
Yes.
Actually, page 81 starts with the provision 7C.
Right.
And if my lords kindly come to the foot of page 82, your lordships will see, my lords, no educational institution
right
imparting any other courses of studies except those provided in subsection 5 shall be eligible for grant in aid from government. Education, but this is very important. But this was the real dispute in this case. Educational institutions established and or managed by urban local bodies, Jilla Parishads, Panchayat Samitis, Gram Panchayats, public sector undertakings or companies or statutory bodies shall not be eligible for grant in aid under this act. Kindly keep this in mind. Now kindly see, come to page 75. My lords have page 75 minutes.
Yes, yes.
This is a proceeding of a meeting of 1/5/2013.
Right.
The meeting of the committee held on so and so in the chamber of the Additional Secretary Higher Education Department of Orissa. The Director Higher Education had made detailed study of the overall picture position of two institutions. So, Lordship may kindly note, my lord, these are the two institutions and therefore two writ appeals. He has also indicated the specific suggestion as to how the two colleges, kindly note, my lord, Indravati Project College and Indravati Mahavidyalaya Jaipatna will be handed over to the government Department of Higher Education. After discussion, it was decided to bring the two colleges into the grant in aid fold by extending the provisions of the 1994 grant in aid to cover these two colleges, but there was statutory constraints to extend the benefit of the GIA to the college managed by the public sector undertaking. Because there was a bar under the provision, your lordship saw, 86.
Right.
82, my lordship just saw page 82.
Right.
There is a prohibition under the act that they won't be entitled to grant in aid. So they were trying to find out how to fit in these two colleges under the GIA scheme. Hence, it was suggested by the Director of Higher Education that OHPC, that is Orissa Hydropower Corporation, would first hand over the colleges to the district magistrate to be managed by the private educational agency. The said agency, after taking over the management, shall apply to the Director of Higher Education for grant in aid, government department, and higher education will take a decision. Kindly note, take a decision to declare these two colleges under the GIA Rule 1994 and authorize the higher education to undertake verification of records for approval and post of. So this was the proposal and the minutes of the meeting. This was the interdepartmental meeting. Now your lordship may kindly see, my lords, page 76 to 80. My lords, 76 is a letter written by the additional secretary, is written by the director of higher education to the additional secretary. Matters relating to the two colleges of Indravati project. So the director is writing. Now what he writes, my lord, in inviting a reference to the proceedings of the meeting held in your office on so and so, I am to state that Indravati Project College, Khatiguda and Indravati Mahavidyalaya Jaipatna are private colleges aided by the Upper Indravati Project, now OHPC, while the college at so and so has a valid governing body approved by the Regional Director of Education, Berhampur. The term of the GB of the other colleges expired. The Regional Director of Education, Berhampur, has been requested to appoint Sub-Collector Nabarangpur as the president of the the GB of Indravati Project, so and so. The governing bodies of the two colleges would be asked to submit proposal. Kindly note, my lord, would be asked to submit proposal to include the two colleges under the GIA fold, provided the government in principle agree to the extent to extend the benefits of GIA available under GIA 1994 to these two colleges. So therefore, the director is saying, this is my recommendation. This is subject to the government taking an in principle decision. Am I clear, my lord?
Yes, yes.
Now kindly come to page 77. This is the enclosed report of the director. Lord, he goes into everything, and finally at page 80, he sends his recommendation. Kindly note, my lords, the last paragraph of page 80.
Yes.
Government will accord their approval to the proposal for inclusion of the two colleges in the GIA Order 1995 in accordance with the provisions made for left out colleges. GIA equivalent to 1/3 of salary cost shall be paid to the person duly appointed against admissible posts with effect from 1/6/94 and after 3 years full cost with effect from 1/6/98. My lord, this is the report of the Director of Higher Education, which is being written to the Additional Secretary at page 6, saying that this is subject to the government in principle agreeing to this decision. Am I clear, my lord?
Yes.
That is a recommendation of the director. He is sending it to the Additional Secretary. He is saying, this is my recommendation. This is subject to what government decides in principle. So, my lord, what your lordships have now saw is two colleges which were not at all entitled to benefit. The government is finding ways and means to get it into the fold. The director was asked to give a report. He made a recommendation. He wrote to the Additional Secretary that this report is subject to the government agreeing in principle to implement it. Now, what happens is, my lord, kindly note C to C if your lordship see the last paragraph. The Honorable Single Judge has relied upon this recommendation, which I will show your lordships a little later. Now, kindly let us see what happened thereafter. Now, would your lordships kindly see, my lords, page 64. Lord, I'm sorry, I'm taking your lordships back and forth.
No, no. It's okay. Yes.
Your lordship, see page 64, observations of the chief secretary. I'll not trouble your lordships with all that. Kindly come to the last paragraph. It is pertinent to note.
Mention.
It is pertinent to mention that the college has not been declared as aided college since the college is being managed by public sector undertaking and is not eligible to GIA under the provisions of subsection 6 of section 7C of the Act. Your lordships have seen that. Similarly, Indravati Mahavidyalaya Jaipatna is now under the control of so and so, being established in the year. It got government concurrence from 85-86 in arts, science, and permanent concurrence in so and so, with 128 seats in arts and 64 in science. The building of the college is situated both in the private and public land consisting of so and so, so and so. To sum up, both these colleges are financed by OHPC at present. They have got good infrastructure situated so and so. The chief administrator of KBK has requested for taking over the colleges by HE department. As reported by Director Higher Education, taking over the college by the government may create resentment as there are old institutions so and so. Your Lordship may leave all that minutes. Come to the last paragraph. In order to overcome the above difficulties, my Lordships have it minutes.
Yes.
In order to overcome the above difficulties, meeting of the committee was held on so and so, wherein the additional secretary HE department, Director Higher Education department, GM so and so, HPC were present. The proceedings of the meeting is at page 172C. It was decided to bring these two colleges under GIA fold. Your Lordship may note it is not GIA 1994. It only says it will be brought under the GIA fold. 1994 is not there in this note because that recommendation the director was subject to in principle approval of the government. If my lord kindly turns over the page, milords, provisions of the GIA order, there was a statutory constraint to extend the benefit of the GIA to the colleges managed by the public sector undertaking. Hence, it was suggested that OHPC should first hand over the colleges to the district magistrate to be managed by a private educational agency. As per the existing provision, the said agency, after taking over the management, shall apply to the Director of Higher Education for grant of GIA. Well, 1994 is no more there anymore. The government in the Higher Education Department will take a decision to declare these two colleges. Kindly note, next line is very important. Under relevant GIA order and authorize the Director of Higher Education to undertake verification of records for approval of posts and sanctions of the GIA. My lord, appropriate GIA.
Yes.
And let us see what the secretary does. Notes above may kindly be perused. As mentioned above, the Higher Education Department does not have any objection to take over the two colleges which would come under the GIA fold on this Higher Education Department for kind perusal and orders. Kindly note, my lord, the date is 13th of August 2013.
Yes.
This is a little important because by this time, that GA 1994 is no more in vogue. It has already been repealed. And I will show you, Lordship, that. So therefore, the secretary, the note is approve relevant GIA order. And the secretary says we will take him into the grant in aid fold. Now, your Lordship may see the first order passed by the learned single judge.
Page 12.
My lord, I'm so sorry. Lordship. Page 12, order of 16th April 2015. Heard Mr. So-and-so, counsel appearing for the petitioner, Mr. So-and-so. The petitioners have filed this application seeking for the following relief. Now, this is a little interesting. Kindly see what are the prayers. Admit this writ petition, call for the records, issue a rule nisi calling upon the opposite parties to show cause as to why the impugned decision dated 6th of January 2007 under Annexure 10 issued by OP number 2 shall not be quashed, and if the opposite parties do not show cause or show insufficient cause, make the opposite party number 2 is OHPC, not the state government. Issue a writ in the nature of mandamus or any other appropriate writs, orders directing the opposite party number 2 to pay the differential salary. Milord, 5 is similar. Kindly see, Milord, 6 is what applies to me. And take further direct the OP number 7 to take a decision. Milord, kindly note this. To take a decision to take over the college within a specified period as fixed by this honorable court. And kindly see, Milord, there are 3 other prayers. Further direct the OP number 1 to treat the petitioners as regular employees till a decision is taken. Further direct the opposite parties to complete the entire exercise within a reasonable time. So on. Now, kindly see what the honorable court says. By Mr. Rautral and senior counsel appearing for the petitioner submits during pendency of these writ petitions, other developments have taken place by way of an additional affidavit. On perusal of the same, it appears that a high power committee was constituted under the chairmanship of the Honorable Minister, Energy in his office chamber, where a discussion has been made with regard to taking over the schools and colleges of Indravati Project College Khatiguda in the district of Nabrangpur and Indravati Mahavidyalaya Jaipatna in the district of so-and-so by School and Mass Department and Higher Education Department respectively. So far as the matter is concerned, the Honorable Minister of Higher Education has agreed in principle to consider taking over 2 colleges as per the appropriate scheme of the department. Kindly note, my lord, as per the appropriate scheme of the department. He advised to constitute a committee comprises of Joint Secretary of Higher Education Department, a Deputy Secretary of Energy Department, Higher Education Department, HRD, examine the detail of the records and papers of these 2 colleges and submit a report within 2 months to the Secretary of Higher Education for consideration of the government regarding the proposal of taking over. Now, my lord, your lordship may skip the next paragraph, my lord. The paragraph after that. So far as colleges are concerned, a subcommittee was constituted by the High Power Committee for submission of its report to the Secretary of Higher Education Department. Accordingly, in the proceedings of the meeting held on 1/5/2013, wide annexure so-and-so, it was suggested by the Director of Higher Education that OHPC would first hand over the colleges to the district magistrate to be managed by the private educational agency. The said agency, after taking over the management, shall apply to the Director of Higher Education for granting aid. Your lordship saw this order at page 75. It's a verbatim quotation.
Yes.
Government of the Higher Education will take a decision to declare these 2 colleges aided under GIA 1994 and authorize the Director of Higher Education to undertake verification of records, etc. The Director of Higher Education has also written a letter to the government-wide annexure so-and-so, wherein, my lordship saw it at page 75, wherein the Regional Director of Education Berhampur has been requested to appoint Sub-Collector Nabarangpur as President of the governing body. The governing bodies of these 2 colleges under the GIA fold provided, your lordship may kindly underline this, right? Provided government in principle agreed to extend the benefit of GIA available under GIA 1994 to these 2 colleges with effect from 1/6/1994. So therefore, the Honorable Single Judge also notes that this is a proposal which is subject to acceptance by the government with regard to GIA 1994. On a consideration of the same, the government will accord their approval to the proposal for inclusion of these 2 colleges under GIA 1994 in accordance with the provisions. Lordship will skip all that minutes. The proposal of the Director of Higher Education has also been duly considered by the government and Secretary to the Government Department of Higher Education, and has also given an endorsement on 13/8/2013. Kindly, Millard, may I show you lordship page 65 once again, if your lordship don't mind. Kindly see page 65, and we are at 66. The note of the additional secretary says, my lord, sir, page 66.
Where are you reading now?
Page 66.
Same. All right.
Yes. Last 4 lines of the additional secretary.
Right.
The government in the Higher Education Department will take a decision to declare these 2 colleges. Kindly note, under relevant GIA.
Correct.
So the directorate said 1994, subject to government approval. Now government says we will do it under the relevant GIA.
Right.
That's the point. And the principal secretary on the next one, he endorses that. We would come under the GIA fold. That's it. So 1994 was a recommendation subject to in principle approval by the government. The government says we will consider it under the relevant GIA. The secretary endorses it. But I'll come back to page 15. My lords, have it, my lords. Last paragraph. The proposal of the Director of Higher Education has also been considered by the government. Your lordships have seen that. Does not have any objection to take over the 2 colleges would come under the GIA fold. As a matter of principle, the government has taken a decision to hand over the institutions under GIA fold, as no such final order has been communicated. My lord, I have no problem with this. In that view of the matter, this court disposes of these writ petitions, directing the government to take follow-up action in compliance of its decision of 13th of August 2013. The exercise shall be completed within a period of 4 months. So therefore, what I decided on 13th/8/2013 at page 66 is to take these schools under the relevant GIA order. Am I clear, my lords?
Yes, yes.
Now, my lords, comes the problem at page 17. My lords, at page 17.
Yes, yes. 5th February.
5th February. Matter is taken up so and so, Mr. Swain. The petitioners have filed this content petition for non-compliance of the order of 16th April 2015, which is at page 12.
Yes, yes.
Passed by this honorable court, and then, my lord, his lordship's quotes a part of that order. In view of the above, after the quotation, in view of the order, there is no iota of doubt the government has to extend the benefit of grant in aid to the institution as per GIA 1990.
This is where the problem starts then.
This is the error.
Right.
Because, my lord, what the honorable court did, it followed the recommendation of the director.
What is the relevant GIA at this point in time?
My lord, they have been given the benefit of GIA 2004. Stricto sensu, my lords, they should have got 2009, but they have got 2004.
And how different is that from the 1994?
1994, they were fully financed. Their entire salary was financed by the state government.
Right.
So here we are talking about, subject to corrections, my lord, about 14 teachers, and it will cost the exchequer about 5.6 crores. My lord, first of all, these people were under a corporation. They were never entitled to this benefit. The government thought it that it advisable to bring it within the fold. So they would come within the relevant fold. There can't be another new thing for them. And if your lordship sees, my lords, kindly just see page 175. My lord, I'm sorry. That's not the one. My lord, my apologies, my lord.
Please.
Well, just
1 minute,
Yes.
Mr.
Yes.
Pareja, kindly, before going that,
yes,
kindly show us what is your averment in para 6 and 7, which
Yes,
gave
madam.
rise to order dated 5th February.
my lord, my averment.
Yes, because the 5th February order shows in
Yes,
view
madam.
of the averment at para 6 and 7 of the counter.
Yes, my lord. My lord, your lordships are at which page?
You see,
I think
5th.
this was referring to the order of the single judge of 5th February 2021. Page 17, which in turn refers to
Para 6 and 7 of the compliance affidavit.
probably wants you to refer to the compliance affidavit.
Yes, my lord.
18, there's a reference. Actually, that 6 and 7 is quoted in page 18.
Yes, my lord.
Quoted in
Mr. S.K. Naik, learned additional standing counsel for the state, contended that the order of this court has been complied with, and he has filed a compliance affidavit on 2/9/21. Mr. Rautrai, learned senior counsel, appearing for the petitioners, pointed out that the order passed by this court has not been complied with in view of the facts mentioned in paragraph 6 and 7 of the compliance affidavit. That in view of the aforesaid decision, the government orders obtained by Higher Education Department for notification of the college in question as an aided college in GIA 2004 was communicated to the School and Mass Department for taking further action at their end. The said department has carried out the said decision, government decision, thereby issuing notification number so-and-so, whereby so-and-so was declared under GIA 2004, and the college was entitled to receive grant in aid under the GIA with effect from 24/10/2017 on the basis of the government notification dated 24/10/2017 and post approval of the government issued by so-and-so, the Director of Higher Education has issued appropriate approval with respect to eligible employees 7 numbers of teaching staff for release of grant in aid in their favor under the provisions of the grant in aid order 2004, making it effective from 24/10/2017 for kind appraisal of the copy of the notification so-and-so, that this deponent has the highest regard and all that. Kindly see note after the quotation, in view of the contention raised in para 6 and 7 of the compliance affidavit, it is made clear.
There was no reference in para 6 and 7 about granting aid order of 1994.
No, it was not there. But what happened was, 1994 was what was said by the director.
Yes.
My lord, your lordships, my lord, the honorable single judge at page 16 says that take further decision in compliance of 13th August 2013. Now, 13th August 2013 does not give them GIA 1994. On the contrary, your lordship sees page 20.
It uses the word relevant.
Your lordships have seen that, right?
Yes.
Yes. Now, my lord, after this order, Lord, kindly see page 100. While we are here, kindly see page 100. This is the notification of 5th of February 2004.
This is the GIA order of 2004.
Lordship pleases. In exercise of powers conferred under section so-and-so, the state government to hereby make the following orders to regulate the payment of grant in aid to private education institutions being so-and-so. Short title, this order may be called the Orissa Non-Government Colleges, Junior Colleges, Higher Secondary Schools Grant in Order 2004. Lordships have it in notes?
Yes.
And it comes into force. It shall come into force on the being published in the Gazette. And this is gazetted, my lord. The lordships have it on March 15th, on 5th of February 2004. Now kindly see 101. At page 101, kindly see section 4.
Repeal and saving.
The Odisha non-government colleges, junior colleges and higher secondary schools grant in order 1995-94 is hereby repealed. Save for the purposes mentioned in subpara 1 to para 3. What did para 3 say, my lord? Whoever was getting the benefit will continue to get the benefit. And kindly see 2. Notwithstanding the repeal under para 1, the private educational institutions which are in receipt of grant in aid from the government under the order so repealed immediately before the date of commencement of the order shall continue to receive such grant in aid. So therefore, my lords, with effect from 2004, 1994 stood completely effaced. And therefore, my lord, in my humble submission, the additional secretary rightly says at page 66 that we will consider it under the relevant GIA. Because in 2013, there is no 1994 anymore. But am I clear?
Yes, yes.
5th February 2004, 1994 goes. is repealed. So there is nothing other than what page 66 could have said. Therefore, they carefully use the expression relevant GIA. So whatever has been recommended by the director has now been superseded. That was the internal discussion between the government.
Yes.
Now in the file, there is relevant GIA approved on 13.8. So therefore, there has been complete compliance of the Honorable Single Judge's order at page 16.
Yes.
Because your Lordship said, take follow-up decision under 13th of August. Lord, against these orders, we had gone to the Honorable Supreme Court.
Page 55.
And if your Lordship comes, thankful to my learned friend, right? Kindly come to page 55.
Right.
My Lord, your Lordship may see the copy of the SLP also that has been filed, and that begins at page 42. Just to complete the records, my lords. If my lords kindly sees question of law, my lords, at page 45.
Yes.
The first one is, my lord, benefits under GIA 94 in view of the law settled. In the meantime, Anup Senapati judgment came where the Honorable Supreme Court said that since 1994 stands repealed, no benefit thereafter. And my lord, the order is at page 55. My learned friend was appearing in the matter. The Honorable Supreme Court on 6th of April passes the following order. My lords have it, my lord?
Yes, please.
This special leave petition is disposed of with the observation that the personal presence of the alleged contemners be dispensed with by the High Court until the final order is passed by it in the pending contempt petition after considering the rival submissions in these proceedings. If adverse order is passed, now this is a little important. If adverse order is passed against the petitioner or the officers of the state, that may not be given effect to for a period of 1 week from the date of the order, to enable the petitioner to take recourse to appropriate remedy as may be advised. The argument is that since the Honorable Supreme Court had passed this order, the appropriate remedy had to be the Honorable Supreme Court on the principle of merger. In my humble submission, my lords, the Honorable Supreme Court did not express anything on the merits. The Honorable Supreme Court only said this, that till a final order is passed, a final order will be passed taking into consideration rival submissions. If any adverse order is passed against the petitioner, the office of the state may not be given effect for a period of 1 week, and petitioner shall take recourse to appropriate remedy as may be advised. So, my lord, if your lordships hold that my writ appeal is maintainable in view of the judgment I showed your lordships,
yes,
then I'll get deeply obliged. Then I am fully in compliance with the Honorable Supreme Court, because option was left to me to take recourse to appeal is maintainable. My lord, kindly see the next order, 15.4 at page 57. My lords have it, minutes?
Yes.
Heard Mr. So-and-so, it is brought to the notice of this court that the state had preferred SLP number so-and-so against the order so-and-so, and the court found an opposite party contemner to have deliberately and willfully violated the order of so-and-so passed by so-and-so. The apex court, on consideration of the aforesaid SLP on 16/4/2021, I need not read it, your lordships. After the order was passed on 5/2/21, the matter was listed before this court on 10/3/2021. With the learned State Council sought time to obtain instruction if the order dated 5/2 has been complied with or not by the opposite parties, and the matter was directed to be listed on 16th March. On that date, this court taking note of the fact that the state has already preferred an appeal against the order of 5th of February 2021 as observed by the opposite parties has violated the order passed by this court deliberately and willfully. Consequently, on 17th March, the principal secretary appeared in person, undertook to comply with the order dated 16/4/21 passed by this court and sought time for the aforesaid purpose. Accordingly, this court allowed 10 days time to comply with the aforesaid order. Again, the matter was listed on so and so. On that date, it was found that the principal secretary has not complied with the order of 17th March as per the undertaking given by him. Therefore, this court also made observation that the opposite parties deliberately and willfully violated the order. The factum of non-compliance of the order passed by this court. But this is the adverse order in my humble submission. Perhaps has not been placed before the apex court in the proper manner for consideration. In any case, in the principal secretary, to the government of Orissa in the higher education department is already undertaken before this court for compliance with the order dated so and so, passed by this court on so and so. Non-compliance of the same is contentious in nature. On 6/4/2021, the principal secretary appeared in person, filed a compliance affidavit that he will have an interdepartmental discussion with the Secretary of School and Mass for compliance of the order dated so and so, and sought time for the said purpose. Accordingly, time was granted till 15/4/2021, but till date he has not complied with the said order passed by this court. It is seen that an officer like the principal secretary of the government of Orissa in that department holding such high rank so and so is showing scant regard to the orders of this court, and despite continuous undertaking flouting so and so. Therefore, this court is constrained to call upon the principal secretary, Government Higher Education Department, to show cause as to why he shall not be suitably punished from the provisions of the Contempt of Court Act for willful deliberate violence of the orders passed by so and so. Kindly see, my lord, page 61. This is the next stop. My lord, have it, my lord?
Yes.
Heard Mr. So-and-so, Mr. S. Mr. Principal Secretary to Education has filed in compliance affidavit incorporating the document as annexure stating that the institutions, namely so-and-so, have been re-notified by the state government to receive grant in aid in terms of non-government junior colleges granted in 1994 with effect from 1/6/94. It is also stated that the Director of Higher Education will remain responsible for entitlement. So, in that view of the matter, since the government has already issued a notification, extension of grant in aid in terms of grant in aid order so-and-so, and here the eligible persons of the aforesaid institution, let the amount be calculated, disbursed. And this is when I came to your lordship, and kindly see, my lord, what your lordship said in the first date. Kindly see order dated 31/5/2021. My lord, have it.
Yes.
At the outset, Mr. So-and-so appearing for the appellant states that although in prayer clause there is also a challenge to the order dated 16th April 2015 passed by the single judge in WPC number so, he does not press the appeal as far as the said order is concerned. Since according to the appellant, the said order is not adverse to it, according to the confines his challenge in this appeal to the aforementioned orders, 4 orders passed by the single judge in so-and-so. When asked about the maintainability of the present appeal against the orders passed by the content proceedings by the learned single judge, Mr. So-and-so places reliance on the judgment of the Honorable Supreme Court with Midnapur People's Cooperative Bank Limited.
But why are you reading the whole order?
My lord?
No, our order, why do you want to read it now?
Yes, my lord, your lordships have only taken note of one fact.
Yes.
Paragraph 6 at page 3.
Correct.
Mr. Parija submitted that after the learned single judge passed the orders and holds the principal secretary has flouted the orders and said order is in nature adverse to the appellant. If further says on 29 direct monetary benefits as a result of implementation should be disbursed and therefore is adverse to the party. Accordingly, he submits the present appeal against the adverse orders in terms of so and so is maintainable. Kindly see paragraph 9 minutes. Considering the fact that the appellant has noted by the learned single judge in order to so and so has issued a notification in purport compliance of the earlier order of the single judge at the pain of contempt and has now been asked to disburse the amounts calculated to each of the eligible persons, the court is of the view that it stays balance of convenience and staying further proceedings in favor of the appellant. But I was checking up, it's about 5.5 crores of public money. And that too, after 2004, the law itself said that 1994 should repeal. And my lord, there is a judgment of the Honorable Supreme Court on this very issue. I need not go into all that. where the Honorable Supreme Court said that after repeal, no benefits. And for that, your Lordship don't need a judgment. The page 100 is very clear.
Yes.
Therefore, in my humble submission, notes, this rate appeal should be allowed. Deeply grateful.
All right. Mr. Tripathi.
But before I take my lords through the documents, which my lord would conclusively establish that the decision that
Mr. Tripathi, you have to be a bit louder.
But before I take my lords through the documents that would clearly establish that what was decided on 13th of August 2013 was nothing except 1994 granted.
Right.
Now, before that, kindly, my lord, see my counter affidavit for a moment. That is page 21 to 24.
You're still arguing maintainability, I suppose.
No, but I'm on something else. The 5th of February order that was challenged before the Supreme Court. But just before that, the government passed this order. Kindly see this. 26th of March. It was withheld in the appeal before my lords. And it was informed before the Honorable Supreme Court. I am inviting my lord's attention to examine with regard to the validity of the subsequent actions taken by the government. By the aforementioned notification in pursuance of the order rated so-and-so and batch of writ petitions, state government so-and-so as an aided institution to receive block grant 2004. Subsequently, the Director of Higher Education so-and-so to extend block grant. Some employees of the said educational institution filed a contempt by not giving the granted benefits under the Orissa so-and-so 94. State government violated the order of the High Court. High Court by order did so-and-so in the above mentioned contempt case has ordered the government to bring the said educational institution under the fold of 1994. By its order did so-and-so in the contempt case, High Court by order personal appearance of the undersigned to receive the charge of contempt for not complying with the order in order to abide by the order of the High Court in the said contempt, and since the earlier government approval has been obtained on the file of so-and-so, approval of the government has now been obtained in the Higher Education Department to bring the said educational institution under the fold of 1994. In view of this, School Mass Education is now requested to revise the notification referred above, take all consequential actions to bring the said educational institution under the fold of grant in order 1994 and extend the benefits of grant in aid again of 1994 to all eligible teaching and non-teaching employees of the said educational institution who are currently receiving block grant. However, this decision, my lord, this is important, will be subject to the outcome of the SLP, which will be intimated by this department due course of time. So this decision was taken before approaching Supreme Court while assailing the order of 5th of February. This decision was taken to extend the grant in order of 1994.
Right.
It was informed before the Honorable Supreme Court on the date of hearing. I have taken a specific stand in my counter that under the pain of contempt, I have passed this order,
right,
subject to the outcome of the SLP. Yes. Kindly interfere with this or else I'll have to comply. Right. Supreme Court declined to interfere, my lord. That was the stand taken there. Now, can I, my lord, therefore, after passing this order, is it not amounting that they're subverting the course of justice? And they came back before the London single judge. Said, yes, we have
but there's a caveat, Mr. Tripathi, you're forgetting. There's a caveat saying at the pain of contempt.
No, they took the stand before the Supreme Court as well. Because this is of 26th of February. The Supreme Court order is, my lord, please see, is of 6th of April. Right. The hearing before the Supreme Court was subsequently. They informed about this.
Yes.
And if it is subject to the outcome of the SLP, right, my lord, what was that outcome of the SLP? I asked that question to myself. Yes. Outcome of the SLP was, please go back before the London single judge, which are adjudicating the contempt. They will give you an opportunity of hearing until such time an adverse order is not passed. The contempt court is at liberty to proceed with the contempt. But therefore, my humble submission is, having passed an order, informed before the Honorable Supreme Court, saying that it is subject to the outcome of the SLP. SLP has resulted into nothing as far as the impact of this order is concerned. Therefore, they can't, my lord, now turn around and say that the writ appeal is maintainable because of these grounds. But I will then invite my lord's attention to what was actually decided on 13th of August 2013. Please see, my lord, if the facts should be distorted, the result is bound to be, my lord, in that way. My lord, kindly see how 13th of August 2013 decision came to be passed. My lord, to begin with, if my lord would be kind enough to see the minutes of the meeting that was referred to in the additional secretary note, which my Lord and Advocate General, my lord, has conveniently withheld to read it on the first occasion and even today. But that is at page 30. Because, my lord, what is approved by the Principal Secretary of the government is not a note. It said notes referred above. So when he says notes referred above, he is referring to both the note of the Additional Secretary plus the note of the Director of Higher Education. Now, therefore, my lord, to see the minutes of the meeting, which is referred to by the Additional Secretary on 1st of May, kindly have a look at page 30. What was decided in that minutes of the meeting? The meeting of the committee held on so-and-so in the chamber of Additional Secretary, Higher Education, Director of Higher Education made details of the study of the overall picture position of the two institutions. He indicated that the specific suggestion as to how the two colleges, Indravati.
Mr. Tripathi,
yes,
let's answer one question. The 2004 GIA order repeals the 1994 order, correct? So what legal sanctity will a document drawn up in 2013 referring to the GIA 1994 have?
So is the repeal of, my lord, 2004. But Lord Regivala didn't mention it before, my lord. The 2004 granting order aid that was now sought to be given to me instead of 1994 stood repealed in 2013. And despite repeal.
By what?
But in 2019.
No. 1 minute. Let's get a fact.
Right. Yes, please have the facts, my lord. My lord, it is true, as my lords have said, as far as the 1994 GIA.
No, 1 minute. You just now made a statement.
Yes.
That the 2004 GIA
was repealed in 2009. As by this time, even
where is that? Where is the 2009 GIA?
That my Lord Advocate General, my lord, has filed, I think, in the memo. And he has just said, well, what should have been given to the appellant was 2009 or 2004. Because 2004 stood repeal as of the date when the decision was taken in 2013.
So anyway, so it only comes to this.
Yes.
It's not improving your case.
Yes.
1994 repealed in 2004, 2004 repealed in 2009, and 2009 repealed in
2019.
2019.
But notwithstanding the repeal, my lord.
No.
Yes.
So how do you revive in 2013?
Yes.
Something that is repealed in 2004?
My lord, it will be revived with reference to the date of application that was submitted by these two colleges way back, my lord, before the repeal, that is 1994. And that action is saved in 1994. Therefore, notwithstanding the repeal of 1994.
That's simply an application, please. There's no decision.
Well, there was indeed a decision. Please see, my lord, to kindly see as to how the minutes of the meeting proceed. Permit me to read, well, the next paragraph.
All right.
After discussion, it was decided to bring these two colleges. Please see, well, the decision is of 2013 here.
Right.
Into the grant in fold by extending the provisions of 1994 GIA.
Right.
To cover these two colleges. Right. But there was a statutory constraint. So it was noticed by this committee that there was a statutory constraint to extend the benefit of GIA to the colleges managed by the public sector undertaking. Hence, it was suggested by the director that the OHPC would first hand over the colleges to the district magistrate. My lord, please see this line. Because of the decision that it would be handed over to the district magistrate, and they have taken a decision to grant me 1994. Pursuant to this decision, the colleges was indeed given to the district collector. That action was taken to be managed by the private educational agency. The said agency, after taking over the management, shall apply to the director for the grant in aid. Government in the Department of Higher Education will take a decision to declare these two colleges aided under GIA 1994 and authorize the director to undertake the verification. May I please see, my lord, who are the signatories here? DP Behera, IS, is the Additional Secretary, Department of Higher Education. It is this DP Behera who, my lord, puts the note to the secretary. Please see his name. Here the decision is unambiguous. 1994 granting aid. There is no quabbling, my lord, about this issue that it is 2004. Kindly see, after making this decision where Higher Education Department.
I'm sorry, Mr. Tripathi, even if there were 6 people signing this document,
yes,
the document should show that they were conscious that as on this date, 1994 stood repealed by a 2004 GIA, and then they were consciously saying, notwithstanding the 2004 GIA, we are still giving GIA 1994 to these institutions.
But I have passed numerous orders in my memo to indicate that even today, the state government is granting 1994 GIA because of the court orders.
Where is that?
Please see, my lord, in my memo. Yes, sorry. To begin with, my lord, kindly see my counter. The first decision.
Was this all part before the single judge, or you've now pulled it out?
But no, my lord, my counter, which I have filed before.
No, 1 minute. Let's be clear, Mr. Tripathi. You know, pleadings in writ appeal shouldn't be going beyond pleadings in the writ petition.
It was there before the Lord single judge. Samlal Pradhan. The state government, my lord, is aware of that particular decision, but they say we can't take advantage of Samlal Pradhan. Kindly see, my lord, page 52. In 2020, they have given to number of colleges the benefit of 1994.
You show us something, please.
Please see, my lord, page 52 of my counter evidence.
Page
52. Consequent upon the dismissal of review and the SLP by the state of Orissa, and pursuant to the, this is the decision of 24th November 2020, the government have been pleased to accord their concurrence for approval of 3 colleges for payment of grant in aid as per grant in order 1994. That's one. And please see the memo which I have submitted. Another 6 colleges, crores of rupees. Now the buggy of crore is being raised for the first time.
So I take it these additional documents will be for the single judge, correct?
Yes, my lord. In fact, this was filed, which is why, my lord, in the writ appeal, in the rejoinder, my friend is saying this Samlal Pradhan is inapplicable for the reason that it was pursuant to a court direction.
No. I am on this IA and the additional documents you filed with it.
No, my lord, these other decisions which are there were not before the single judge, but page 52 was there.
Mr. Parija, you have this IA?
I have served a copy.
My lords, I don't have it, but kindly see, my lords, the one my learned friend is showing at 52, there a SLP and review was disposed of.
No. I'm only on that, and that in your turn you can reply.
Yes,
I'm on this IA 1732.
Yes, my lord.
He has placed with it orders in several matters.
No, my lord, it was not before the learned single judge because nowhere these have been referred to by the learned single.
No, he asserts it was there for the single judge.
Can you mark the date also?
No, I'm on this IA 1732, please.
Yes, my lord.
Yes, my lord. IA, the orders referred to in the IA were not before the Lord and single judge. But the order referred to in the counter, page 52 was there.
That's not what I'm asking. I'm asking what the documents placed with the IA.
Yes, my lord, these are not there. These are all orders passed by the government, but not.
No, do you want to examine this?
I'm sorry, my lord.
Mr. Parija.
Yes, my lord, I will have a look at them.
Because if it is not a one-off thing like the one at page 52, if you routinely be granting 1994 GIA to others.
My lord.
And these are all orders of 2012, 14, 16, 17.
Series of orders, except
That's right.
this college.
Let him examine it.
That's right.
I will examine it, my lords.
All right. IA 1732 of 2021. During the course of his submissions, Mr. Tripathi referred to the documents enclosed with this IA and candidly stated that these documents were not before the learned single judge, although they support his contention that the GIA 1994 benefit was extended to institutions even after the repeal of the said GIA by the subsequent GIAs, GIA of 2004. Mr. Parija states that he will examine these orders enclosed with the orders enclosed with the IA and respond tomorrow, day after, Monday.
Monday,
Monday
is 20th. Well, can we have it on 21st?
All right, 21st. All right. All right. All right. 2 o'clock. 2 o'clock.
Well, at 2 o'clock.
You can even appear virtually.
Well, I'll do it in through video. That's why I thought it will overplay. So
I know.
We'll do it video.
All right.
Grateful.
Yes.
37. Please, my notes. At 37, the petitioner states that challenged the order passed by the Honorable Tribunal. The short point for determination before my notes is that whether in a pension scheme after the cutoff date, the person can claim the pension. That I am supported by my notes. If I request screen sharing, I am supported by decision of the Honorable Supreme Court.
But first hurdle.
Here, the saving grace could be, if I can say so. The notices were issued and they have on 27/4/2021. And here, the other part is is that he is not prejudiced because the pension is in future. Immediately after joining, he raises an issue regarding pension.
No, is there a similar matter here?
Item 37.
No, you've quoted something in para 11.
That's it.
Just see that para 11.
Yes. Several other matters. In fact, since these
No,
are...
the 22057 of 2019 is pending.
Yes, I suppose it is pending.
No, my lord. That was dismissed by your lordship.
Where is that order?
My lord, today I have given your lordship.
Which date my friend may suggest? May I request my friend on which date?
Double 277. This is 2277. The one we are now hearing. In that he must have given.
My lord, on that day, 3 matters, along with that, on that day, 3 matters are there. I have given today, your lordship may see. Your lordship dismissed and it was also, yes. This was the reported decision today. Your lordship may see, this is the reported decision 22057, which your lordship wanted to see. I have given that judgment. Your lordship may see. This was the reported on the ground of delay. Your lordship may see.
So merits were not discussed there.
Not discussed, but this ground of delay.
Yes, well, here the honorable court was
This
to
case
admit-
No,
admit that
will
issue.
consistent, Mr. Sahu, then. Even here there is delay anyway.
Well, here it has been admitted, I suppose. On
No, no.
27th court.
This is also 1 year, 6 months after.
Correct,
I have
correct,
given your lordship's judgment by enclosing the
My lord, may kindly
to the
consider
present
here,
today, my
it is
lord.
opposed to public policy and it is a future benefit. And my lord, yes, my lord, it is, he is not prejudiced. My lord, it is not that by delay the sea has been deprived of something.
Let's be consistent. Then in all those other matters, you would have to implement the order, subject to what Supreme Court says. It's better you get an order from the Supreme Court, because then you'll carry all this there. Have they carried anything to the Supreme Court? Any of these orders?
No, my lord.
Not yet.
My lord, apart from that, your lordship may see Annexure A/2. Before this honorable single judge, they have stated by filing Annexure A/2, your lordship may see. Today I have given that document. They have stated before in the content petition that we have implemented the order by writing the letter for opening up the GPF account. After 2 years, they have approached before lordship. When the content petition I have filed, I have given the content order.
All right.
And that was noted by your lordship in the order.
All right. In para 11 of this petition, it is stated as under. Reproduce para 11. This court has in its order dated 15 July 2021 in the aforementioned dismissed the aforementioned writ petition civil 22057 of 2019. In the judgment reported as State of Orissa versus Sanjulata Sethi 2021 2 OLR 401 paragraph. Even the present petition challenging the order dated 2/8/2019 of the OAT was filed only on 19/1/2021. The explanation offered in para 12 of the petition for the delay in filing the petition is not convincing. Stop. In that view of the matter, the petition is dismissed on the ground of delay in laches, and in view of the dismissal of writ petition civil 22057 of 2019. All right.
Stay order back.
Dismissed.
Vacant. Obliged.